Hello, everyone. Welcome back to another day of LAV's new grantee orientation. We are excited you're with us. We have a few great speakers today from a couple of organizations, both the Center for Survivor Agency and Justice, and then the Victim Rights Law Center as well. I'll let them introduce themselves when they come on. But for now, just remember that you can submit questions via the chat box at any time throughout the presentations today for your presenters to eventually get to and answer. And that the closed captioning information is provided in the chat. I believe Annette just popped it in there. So with that, I'm going to turn it over to Nkiru with CSAJ, the Center for Survivor Agency and Justice.
Thanks, Miranda. Hello, everyone, and welcome to today's presentation. My name is Nkiru Aduba. I use she, her pronouns. I'm the Capacity Building Manager at CSAJ. And today we shall be discussing consumer rights and economic justice for survivors, expanding our approach to safety. Next slide, please. So these are some of the learning objectives for today. We want to understand why economic and consumer advocacy matters. What are the economic issues or consumer issues that arise for survivors? What can you do based on your role? And how can we at CSAJ support your work? Next slide, please. At CSAJ, our mission is to promote advocacy approaches that remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. We envision a world where all people have equal access to safety, physical security, economic security, and human dignity. Next slide, please. Okay, sorry, I was looking at the chat. At CSAJ, we believe that there is no safety without economic security, and I think the rest of this presentation would further buttress that point. Next slide, please. So now we discuss the reciprocal nature of abuse and economic hardship. There is a cyclical link between poverty and vulnerability to violence. From our research, the rates of reported domestic violence amongst women that were receiving public welfare is like 70%. From homeless women, it's like 50%, and all women generally is 25%. Women living in poverty tend to experience more domestic violence. This is not because they are poor or their status, it's more because they do not have access to safety. Basically, they don't have the means to get away from their abuser, because getting to safety requires some economic funds. Next slide, please. I'd like to start with the definition of economic abuse. Economic abuse involves behaviors that control a woman's ability to acquire, use, maintain economic resources, thus threatening her economic security and potential for self-sufficiency. Some examples of how economic abuse show up is the abuser prevents the survivor from going to work, maybe by hiding the keys or the car keys, or even showing up at her workplace, his or her workplace, and being unruly at the workplace as well. Other ways can include depriving the survivor of access to resources, to her own funds as well. Next slide, please. So the impact of domestic violence in the life of a survivor is vast, and the economic impact of domestic violence includes income and job loss, housing instability, limited transportation, decreased access to childcare. These are only a few of the impacts of domestic violence. Next slide, please. So at CSAJ, one of our former experts has defined the economic ripple effect of domestic violence, basically looking at the whole life cycle of domestic violence, the effects it has on the survivor's life in different stages of the relationship. For example, during the relationship, some of the effects of domestic violence include job loss, credit damage, theft, debt, missed work days, foregone professional advancement, because abuse has a way of hindering one's advancement in your career and also in your education as well. And then at the stage of leaving the relationship, there are also all sorts of burdens like the relocation costs, the incurred debt from marriage, the legal fees that come into play when a survivor is getting a divorce. And then in the short term, you have foregone wages, you have housing instability, cost of childcare, increased cost of independent living. And then the lifetime effects of domestic violence include mental health effects, slow professional development, increased vulnerability to future abuse. Next slide, please. So this is a question for the chat. What aspects of the ripple effect that we just discussed, or the effects of domestic violence, have worsened due to COVID-19? We'd like to hear from you. If there's anything you've seen that matches up to what we have discussed so far. Okay, so some isolation, yes. Lack of work, housing affordability, yes, that is one of the complaints that we've been seeing as hearing from advocates as well. Inability, yes. Housing crunches, yes. Yes, price of everything going up, yes. Lack of childcare, increased everything, yes. Yeah, these are great responses. Next slide, please. So now we discussed sorry, Jazz, could you go back to? So now we're going to discuss the compounding factors that survivors face in addition to the abuse and all the other issues and barriers they face. Next slide, please, Jazz. So these are some of our graphs from our research department that basically show that social inequality constrains survivors' options for safety. Basically, these graphs show, sorry, excuse me. Basically, what these graphs show is that people who are marginalized by race, sexual orientation, gender identity, physical and cognitive ability, citizenship status, and ethnicity experience domestic violence and other violence at a much higher rate than those who have social privilege. For example, we've seen that while 1 in 3 white women report experiencing domestic violence, the rates of abuse increase dramatically, 50% or even higher for those who are marginalized by race, ethnicity, sexual orientation, gender identity, citizenship status, and persons living with disabilities. So given the link between the economic hardship and safety, it's important for us to address the systemic inequalities that marginalized survivors face. Next slide, please. So some of the structural barriers, in addition to domestic violence, some of the structural barriers that survivors face when they're accessing safety or trying to get out of bad situations include transportation, housing, education, employment. These are some of the issues that you mentioned in the chat. What does it look like? It looks like distance to court services and also having to balance taking time off work to go to court for court appointments and stuff like that. It also looks like service responses. It looks like systems bumping against each other. So you have the case of trying to access maybe social services and also trying to access legal services as well, and all the barriers that come up with that. It also looks like when judges bias or preference for two-parent homes, it also looks like the number of like requirements that survivors have to fill or have to match before they access services. So these are some of the structural barriers as well. And then there's also the impact of policies that affect survivors. For example, how things like credit history and credit scores may affect survivors accessing housing and other needs. Next slide, please. So at this point, I'd like to ask if there are any questions or anyone wants to share some thoughts about what has been discussed so far, or just any additions. Okay. Well, we can move on, and then maybe if we have questions at the end or comments at the end, that will be fine as well. Next slide, please. So now we want to lay the landscape for survivor-centered economic advocacy, which is something that we at CSEJ think is very crucial when advocates and attorneys are working with survivors of domestic violence and sexual assault. Next slide, please. So we have a multi-level approach to economic advocacy for survivors, which is very important to adopt. So at the smallest level we have enhancing individual advocacy. And then in the green semicircle, we have, yes, you will get the slides. We have the organization and community reform. And then at the highest level, we have systems and policy change. Next slide, please. So breaking this down further, what does enhanced individual advocacy look like? This basically addresses both the physical safety and economic safety needs of survivors. Like we said before, there is no safety without economic security. This looks like economic advocacy and asset building strategies, which are ineffective without addressing safety needs and privacy needs of survivors. It's important to emphasize that when you're conducting advocacy with survivors, that you prioritize the safety of the survivor. So when you're trying to intervene or work with a survivor, you should always pay attention to what in your work may be triggering maybe an abuser or exposing the survivor to more harm, and trying to caution for that and make sure that you're not making sure you're doing no harm. And at the organizational and community reform stage, this requires partnerships and collaborations between different subject areas. So domestic violence, anti-poverty, immigration, anti-racist fields, basically attending to the ways in which physical and economic risk facing survivors fundamentally shape their opportunities for securing safety. So you have to be attendant and make sure you try as much as possible to form relationships with other organizations who may be able to help the survivor in different areas. So for example, at CSEJ, some of our technical assistance has involved collaborating with different attorneys and advocates from different fields to give the survivor a more holistic result. And then we look at systems change, what local and federal efforts can be done to remove institutional barriers, to remove those systemic barriers that we talked about earlier. How can we identify and implement laws and policies and conduct impact litigation that addresses systemic inequalities? Next slide, please. So moving on to consumer rights advocacy for survivors and why we think it's important. Next slide. So why we choose to focus on consumer rights for survivors is because we feel it provides more holistic support for survivors. So we think it has the potential to equip survivors with critical information, tools, and options to address profound and long-term economic harms. What does that stem from abuse and poverty? What does this look like? It looks like credit reporting and credit repair. It looks like debt collection defense, credit discrimination, student loans, economic relief in family law. It looks like addressing issues of economic barriers in civil court, economic barriers to housing, to employment. Next slide, please. And then these are some of the barriers that survivors face. So they're payday loans. We have examples of payday loans. So for example, Ari is unable to open a banking account because the nearest bank is miles away, rent is due, and they may have to get her check cashed at the local check cashing store again. That's one barrier. And then there are court-related barriers as well. And there's credit-related barriers to housing as well. And for example, digging deeper into the court-related barriers. For example, Jenna went to court to get a protection order. She had to wait all day before her case was called, and now she has to go pick up her children from school. The clerk says she must choose between her safety and picking up her kids. She'll have to come back tomorrow. This means that she has to miss more days at work, which is a challenge. And I see in the comment that someone said immigration status barriers as well. Yes, this is also a very big barrier as well, because it impacts them getting, depending on your immigration status, it opens you up for access or denial to public services. So some immigrants can't access public services, while some can accept a little. Next slide, please. Yes, and this is more of the barriers that we're talking about. There are coerced and barriers to employment. There are coerced issues that survivors face as well. And for example, Jamie's partner forced him into signing fraudulent tax returns. Now his wages are being garnished due to tax debt. We also saw over the pandemic, a lot of abusers stealing child tax credits from survivors as well. And then there's the coerced debt and debt collection. For example, survivors may owe, in this case, Mona owes 10,000 to 3 different credit card companies for purchases that were made by her abuser without her knowledge. This is actually very common. And this is something that advocates have told us that they have uncovered during their intake process. And then they have survivors who are being harassed by debt collection agencies. And then you also have survivors being coerced and forced into writing fraudulent checks as well. So these are some of the challenges and barriers and consumer issues that survivors are facing. Next slide, please. So why we emphasize consumer rights advocacy as critical is that while most strategies regarding domestic violence and helping survivors or working with survivors have focused on financial literacy training, we think that's good and fine in itself, but it barely scratches the surface, because when you're talking about financial literacy, for example, it has the tendency to make survivors think, oh, maybe I'm not literate enough in budgeting. Meanwhile, you can't budget your way out of hardship or some of the abundant barriers that you face. So it's not just about knowing how to budget. it's more about how can we remedy survivors' accrued economic damage? How do we minimize their expenses? How do we protect their current assets? It involves helping to repair like credit history so that they can secure housing and live a life of self-sufficiency. We believe that consumer law does all of this. Next slide, please. So I'd like to know now, what kind of economic issues do you advocate for in your work? You can just put it in the chat. So child support, spousal support, claiming the child tax credit, possession of house, access to benefits, yes, family support, eviction, credit repair, child support expungement. So just from your responses, I see that a lot of you are doing really holistic work to help survivors access services, sealing evictions, yes, unemployment benefits. I think at this juncture, it's important for me to emphasize the really critical role that you all play in helping survivors unemployment benefits, making sure immigrants know what documents are required by an employer. Yes, changing social. So it involves a whole host of things that you guys are working on and which are very important and meaningful to the survivor. I would actually say, well, I'm an attorney, but I feel like advocates get to do more holistic work and provide more holistic support to survivors as well. Next slide, please. So now we move on to, I'll address questions at the end of the presentation. Now we move on to what CSAJ provides, some of our key projects. So we have several projects at the moment. We have the Access to Justice for Survivors project. We have the Accounting for Economic Security and Atlas for Direct Service Providers, which has rounded up. We also have the Consumer Rights for Domestic and Sexual Violence Survivors Initiative, and we have the REAP project, so the Racial and Economic Equity project as well. Next slide, please. So the Access project basically deals with non-lawyer legal advocates, which a lot of you on here are, which is basically advocates that help survivors in different areas, but are not attorneys. This project addresses the costs and removes systemic economic barriers and inequities related to domestic violence and sexual assault. Next slide, please. So the audience is the non-lawyer legal advocate. So advocacy includes things like legal advocacy, safety planning. So this is our primary audience for this project. Next slide, please. Some of the project activities include the e-course learning cohorts, the individual technical assistance, the webinar trainings, the peer exchange course. Next slide. So the e-course is basically an 8-part e-course, which is hosted on CSAJ's website and Canva as well. And we provide like video format of some of the courses. So you have some training on survivor-centered economic advocacy, economic safety planning, economic relief in family law, coerced debt defense and advocacy, innovative advocacy strategies, intersectional anti-oppression, how to integrate an intersectional anti-oppression approach into advocacy. And then the e-course cohorts takes groups of advocates through the 8 e-course modules, and there's discussion and individualized and group technical assistance. So you could reach out to us for questions that you have concerning these different areas, and we're able to help and also bring on experts to also address some of these issues. Next slide, please. So we also have the Consumer Rights for Domestic and Sexual Violence Survivors Initiative, which was renewed again for the year 2022 to 2023. Next slide. And the objectives of this project include developing a culturally relevant civil legal advocacy practice to address consumer needs of underserved survivors. It includes building organizational capacity of grantee programs to reach underserved communities. One of these strong objectives also is trying to foster partnership between family law, consumer law, immigration law, and culturally specific programs to deepen the impact of advocacy. Next slide, please. The primary audience for this includes civil legal attorneys, advocates, program and organization leaders, coalitions, stop administrators, rural grantees, LAV grantees, and stop grantees as well. Next slide, please. So for the Consumer Rights Project, it focuses on debt, and coerced debt is a key part of debt that is the target area. So what does coerced debt mean? Coerced debt means all non-consensual credit-related transactions that occur in a relationship where one person uses coercive control to dominate the other person. So one of the key things to emphasize is that it is non-consensual. That is, the survivor does not consent to any of these transactions that is happening. And then looking at coercive control, what does that look like? It's systematic, ongoing use of violence, threats, intimidation, isolation, and control in order to restrict the victim's autonomy and liberty. Next slide, please. So practical examples of what this looks like. It looks like how it shows up. It shows up on credit cards. So charges on your credit card without permission, on the survivor's credit card without her permission. It looks like payday loans. It looks like auto loans as well, and mortgages. We believe that advocates are critical. We believe that advocates are critical in helping survivors identify and screen for coerced debt. In some of our trainings and peer exchange calls, we found that advocates are usually very key in identifying during an intake by asking certain types of questions to the survivor to uncover coerced debt. So you may not know it as coerced debt per se, but when you interview your client, there are some red flags that may come up. Maybe you're talking to a survivor and they say, they don't know how some charges got on their credit card, or they may tell you, I don't have full control of my credit card. The abuser has access to it, stuff like that. Next slide, please. So far, since the pandemic, these are some of the issues that we have seen the advocates and attorneys are informing us about that have increased, like some of the issues that survivors have been going through. restricted access to stimulus and child tax credits, abusive partner stealing checks, maybe wrong or old address, abusive partner also claiming custody of children to collect, claiming that they have custody of children to collect the child tax credits. This is one of the issues that a lot of advocates reported to us. And then also there are challenges with survivors also understanding consumer products and the benefits, and this particularly impacts immigrants, rural, older, and people with disabilities as well. Because most consumer product information is online, and it's in English as well, and maybe some of the languages are not accessible to survivors. These are some of the challenges that economic issues that we've been hearing about. And then there's also the big issue of survivors having little access to public benefits due to their immigration status or lack thereof. And then even in accessing services for those who are fully documented or US citizens, there's also the challenge of constant requests for documentation, asking survivors to prove something or to show evidence that they have a certain document before they access services. And this is basically impeding the access to services for survivors, and is actually re-traumatizing, because imagine asking a survivor to kind of prove that they have been traumatized. And we strongly advocate that systems and people that work in these systems believe survivors and not make it difficult. They should not make an already difficult situation worse. Next slide, please. So some of the project activities under the consumer rights projects will include creating a COES debt clearinghouse. This would look like providing a space on the web where you can find any information, whether you're a beginner in learning about what COES debt is or an expert, things that relates all sorts of facts, policy, research on COES debt, examples. We hope to house that on our website so that everybody, whether advocates, attorneys, students, can access it and be aware of what COES debt is, and also be aware of how to help survivors who are dealing with COES debt. And then we're going to also have legal roundtables. These will look like discussions where you have advocates and attorneys basically talking about the consumer issues that survivors face, particularly looking at the consumer issues that underserved populations face as well. It also looks like another activity would also be in building organizational capacity and partnerships for economic justice, and also have like cohorts go through this training as well. It will include a training tour to provide advocates with more consumer rights advocacy knowledge so that they are better equipped to help their survivors. And then we would also produce consumer rights newsletters and provide individual technical assistance as well. Next slide. So here are some of the projects, some of the resources that CSAJ has developed, which I think can be useful to you in your practice. There's the Consumer Advocacy Toolkit. There's the Economic Ripple Effect Facing Immigrant Survivors, which shares some creative legal advocacy solutions for those of us on here that work with immigrant survivors. And then there's the Compendium on COES debt advocacy, which basically, like I said, is useful to advocates and attorneys and anyone who is interested in learning about COES debt. It has survivor scenarios so that you can which kind of exemplify coerced. So it's easy, it's relatable, and you understand how it can show up. We also have, for the attorneys on here, we have some legal articles as well on coerced, and then kind of the landscape of coerced in different states as well. Coerced law in different states. So this slides will be shared afterwards, so you can just click on the link and go directly to it. Next slide, please. So more on our individualized technical assistance. So we basically provide targeted support to organizations, advocates, and attorneys. We pull together, we're lucky to have national connections across, expert connections across the nation that focus on different areas and have different areas of expertise. So we could pull in experts on survivor-centered economic advocacy, on access to justice, on consumer rights, family law, because lots of times when survivors show up with issues, these issues are usually multi-pronged. So we're able to bring experts from different fields so that they can provide like a more holistic solution for survivors. So you can email us at info@csaj to get TA. Next slide, please. And these are some of our products that may be useful to you. There's the Starting Economic Conversation Advocacy Guide. There's our Access to Justice e-course, which you can enroll in and do either any course that you like. So the email is info@csaj.org. So I think there's an error in one of the, and then we have a resource library, which is rich with all sorts of information on economic advocacy for survivors, which may be helpful to you. There are past webinars on consumer issues. There's a guidebook chapter. There are guidebook chapters. Well, there's a guidebook itself on consumer and economic civil legal advocacy for survivors, which has like extensive information on different topics, including credit, predatory lending, debt. There's also an assessment tool for attorneys and advocates, and there are past webinars on consumer issues as well. Next slide, please. These are some of our reports and the guidebook, which I just mentioned. There's the Showing Up report, which deals with disrupting racial inequity, which faces survivors. There's the Atlas, Accounting for Economic Security. Next slide, please. Thank you. So I come to the end of the presentation here, and if there are any questions or any comments, please share with us. There's I got a question from someone earlier, Anamida. Sorry.
There's also another one here in Kiru.
Okay. So the question for us is, if the abuser claims and gets the tax returns and withholds it from his ex-spouse and children, are there steps to protect the children from continuing to be claimed by the abuser?
Yeah, I mean, without getting in depth into sort of legal strategies on this call, I think that what the person asking about is, it really gets into the area of innocent spouse relief, as well as just broader federal tax advocacy. One of the resources that Nkiru referenced was CSAJ's guidebook on consumer rights and economic civil legal advocacy. And there is a great chapter in that resource. I mean, that resource has a lot of information about many different topics. So definitely encourage folks to check it out. But one of those is specifically focused on federal tax relief. And I think that would be a good sort of introduction to people who are interested in getting a better understanding of the broader landscape around tax-related remedies for survivors. I mean, it also brings up the issue of partnership building, and we have some specific resources, of course, on partnership building. One of which is our economic justice report around our pilot project work, and that was included in the resource list, and you'll get that once you get the big PowerPoint deck. But you know, so much of this work intersects with different areas, and there's absolutely no way that any one attorney could have all of the expertise in all of the areas. And so that, you know, that's actually kind of dangerous business. We're not recommending that. So instead, what it really requires folks to do, depending on your context, is thinking both internally, organizationally, internally, and also externally about what are the kinds of partnerships that I need to be building if I am really centering economic justice in my advocacy work. So lots of tools to help organizations think through some of that partnership building piece as well.
And then there's another question about the focus of our materials, whether they're focused on federal or state law. So our materials basically help any advocates or attorney, or give some perspective for any advocates or attorney working on consumer issues, family law issues. So providing the survivor-centered economic advocacy perspective so they can be applied for, I think, attorneys or advocates either working on a federal level or a state level would find something useful in our resources. So encouraging you to look at it.
Yeah, I also want to lift up the typed comments that Jazz has been sharing, which are great. In terms of the tax question, she's suggesting webinars that reside on CSAJ's website. We have several, some specifically about tax, but some about the intersection between family law and tax law, which is worth checking out. And then, yeah, also our 2024 cohorts are going to help with some of the partnership building stuff. That may have been Jazz or Sarah or both, but whoever it was, super thankful for your input. There's also a question from Sylvia Martinez about whether materials are focused on federal or state law. So, yeah, I don't know if you want to speak to that, Nkiru, or.
Oh, I just did.
Oh, sorry, I was probably combing through these other responses, did not hear you.
Yeah, I was just saying that our work is good for anyone who is doing like survivor-centered economic advocacy and can be applied whether state or federal. I think you'd find something really useful in either. There's no, I think with the exception of, I think our NYC report, we don't focus on states specifically. I think it's more broad, so that either states or if you're working in national level or state level, you can find something useful in it. So there's no restriction per se.
Yeah, And I think that in some of the areas where they're, where clearly the legal practice requires familiarity with like a particular state, what we try to do is give a general framework of, what the landscape looks like regardless of what state you're in, and categorize different types of state approaches. And then, yeah, it is generally speaking the task of whoever's seeking out that help to try and get connected with their particular state's law.
Yeah, and I think also, in the issue for CSAJ's resources and the issue of when it comes to states, I think under the quested topic, we have like a resource index, which has like the latest laws in the several states that have quested laws. So if you go under our index, you can see, like, for example, Texas has some laws on it. So we have captured the state-specific laws in that particular topic. So that may also be useful to you. Are there any other questions or comments? If there are none, I think maybe we should take a break, because I know these programs, this training session is like several hours, so maybe, okay, I think there's one.
I think what the first question is raising here, this is my interpretation. Feel free to jump in if there's something different. So as folks may know, the most recently reauthorized edition of the Violence Against Women Act specifically provides a definition of economic abuse within the federal legislation. This is super exciting because CSAJ's coerced debt working group, the experts on that working group were instrumental in helping to provide some of the understanding so that people doing that policy work could be able to adopt it and put it into practice. So one of the things that I think we see on the horizon in the coming months and years is thinking with you all about implementation. What are the ways in which advocates and lawyers and programs can really make best use of the newly recognized economic abuse definition in the Federal Violence Against Women Act. I know in Kiru you have some specific plans, I think, in the works for the how of that.
Yeah, so we're really excited about the economic abuse provision, and like Erica said, we want to think through ways in which so now we have this fantastic provision. What do we do about it? How do we use it? Is it possible to use it in court cases to argue for more economic relief for survivors? So thinking through things like that, and also thinking through ways that apart from family lawyers, how can consumer attorneys use that? How can other attorneys of different or other advocates of different fields use that in their work? Yeah, and basically trying to broaden the scope of relief that survivors can access through that provision as well.
There's also a question from Rosario. I don't know if you want to. So here's what I'm reading, but feel free to either verbally or by typing fill in some gaps. I'm talking about threats that one of the threats the abuser makes, if the victim tells the police they'll kill, I think that must be kill the victim, and the police will not keep the abuser arrested until they go through the process with a judge. Do you mean a criminal process or a protection order process, or either one? What do you think?
Either one, we have one situation like that, and when we went to the police and everything, after at least 6-7 hours, the abuser go out to the police, and it's it's not safe. They don't feel security that they can come back to the house, even they have all the protection. We're not sure if there's something like we can say, yes, go. He's not gonna be close to you if they relieve them from the police. Sorry if my English is, if I understand.
Your English is wonderful, and thank you for your
you.
question. Yeah, so my reaction to that is, that there are, that police departments are compelled to comply with judicial orders that are in place, right? So if there's a civil protection order that's in place, which is totally separate from the criminal justice system. So if a survivor of domestic violence with your advocacy or on her own decides to go and get a civil protection order, then that order the judge can make several different provisions within that, and some of those may require the police's compliance with those provisions. The criminal justice piece is separate, and so that requires partnership depending on the survivor's wishes. So yeah, we're happy to talk more in depth with you through individual technical assistance. Where are you located?
We are in New York, Rockland County.
Oh, that's what I thought. I'm familiar with your project. Yeah, I've heard about you before. So, so yeah, give us a call, email us. Very, very happy to talk more about this with you.
Thank you.
If there are no more questions, I think we should take a break before the next presenter starts at 2:00. Maybe just get up, stretch, and have a sip of water or something. Yeah.
Thanks, everyone. See you soon.
See you in a bit. Thank you.
All right, it is 2:00. So Katie, if you're ready, we can go ahead and get started again.
I am ready. Good afternoon, everybody. My name is Katie Von Melindy. I use she, her pronouns. I'm going to start sharing my screen in just a moment, but I just wanted to say, just scrolling through all of your names made me feel so much less alone. I'm like, wow, look at all those advocates out there today. Sitting here thinking, learning, growing together. It's such an amazing opportunity. I feel so privileged to share this space and time with you. I love it when we're together in space, although, and I can just share the joy of the ability to learn from each other and grow together. And I know that if we were all in the same space, just the amount of wisdom that would be bubbling up would be just overwhelming. So I'm just so happy to be here with you all today. And so I'm just start sharing my slides with you in just a minute. Get that ready. Let me see if it's gonna let me do that. Oh yes, here we go. All right, I'm gonna move my frame so you all see the right thing. So I am here today also with the Center for Survivor Agency and Justice. I am one of their consultants that does some work for them and have had the amazing opportunity to work with them as an expert advisor for many, many years now. So I am so thrilled to be here with you all today to talk about this super important subject. So I am going to focus my talk today on survivor-centered economic advocacy, and we'll talk more about what the heck that means. But I know that you are all like experiencing all of these speakers today, and you're probably like cultural, like your mind is ping-ponging back and forth between styles and format and all that stuff. And so I just want to take a moment to have you take a deep breath and prepare for my style, which is this. So I would like you, as much as you possibly can, for us to be as interactive as possible in this weird virtual space where you're listening to different people all the time. I love reactions. So, anything you can pop up on the screen. Maybe you're just sick of hearing me talk and you want to do a funny sort of weird reaction. I don't care what it is, anything to let me know you're out there, you're listening, you're thinking, you're growing. That would be awesome for me. That also means I'm happy for you to chat at any moment. I'm sure my coworkers and friends will be helping me observe the chat if I miss things. And also, if you need to unmute and talk to us, let me know, where I'm really happy to hear from you. I also know as advocates, we are oftentimes asked to have our focus and attention on like 20 things at once, which is not only exhausting, but it actually have pretty good research to show that it leads to more challenges with vicarious trauma. So some part of being trauma informed for ourselves is also doing as much as we possibly can to focus on one thing. And I know that it also feels like a luxury. And it's a luxury you deserve. So I'm hoping that for this time together, and I know this is all day, but I'm hoping that you can try to give yourself some luxury of focus and the ability to really be with one another and listen and think and grow together. That also to me requires that we have some grace with each other, with ourselves as we're talking about these topics, and with me, who's all in this screen, in this face far away from you and not able to react to your facial reactions and to understand all of our multiple identities all at once, and that we're all trying to learn and grow. So I would hope that you would give all of us that, and that if there are things that are feeling like they're not sitting right with you, you're wanting to push back or think about in different ways, I would hope that you would feel comfortable to write and chat about that, or to get in touch with me later so we can kind of think about those things, or if you feel really brave and courageous, to share that out loud. I know we just had a break, but we might have a little minute of a break in between my talk as well, just so we get some time with that. And I would also hope that for our time today that we would get some opportunity of reflection. Part of this work that requires us to really understand ourselves, have some reflexivity in understanding when we're having different responses and reactions. And interestingly, many of us don't understand or haven't paid attention to or don't know what's happening for us when it comes to talking about money. And some of us may feel very comfortable having really complex conversations with folks about their trauma or their physical or sexual violence, but yet have a real challenge talking about money. Maybe many of us, because of our own financial struggles, or maybe missteps we've made, or maybe we don't know how to sit with how we are with money. And so just want to acknowledge that and ask for some reflection within that. Does that sound all right for everybody? Any virtual thumbs up for me that you want to share kindly? I see Myrna, thank you for nodding, and yes, look at that. All right, Myrna, thank you. So that leads me to this question of who are you? Who am I? Why are you here? And why am I here? So unfortunately, I don't get to see that. In real life, I'd love to have a long conversation about all of this, about who you are and why you're here. And so hopefully, if you feel comfortable writing in chat what that looks like for you, feel free to do that. I'll give you a little opportunity to tell you who I am and why I'm here. So as I said earlier, my name is Katie. I'm based out of St. Louis, Missouri. And I've been working with survivors of intimate partner violence for over 20 years. And I started really getting interested in this work when I was working in a dual program, domestic violence sexual assault program in rural Iowa, where I was really faced with a lot of survivors that I was working with. And when I was talking with them and trying to understand what was going on for them, I was really hearing what they were saying is that for them, actually, the domestic violence was a big problem. But one of the bigger problems was finances, and the interaction between the domestic violence and the finances was a huge problem. And I didn't feel like, as an advocate or a social worker, that I had much experience or knowledge in really how to help people. Like many of you probably who worked in other organizations, I was given kind of a budget form and told to budget with people, but no one really ever gave me the skills or had conversations about what does it mean? And what does it mean to budget with people who are experiencing economic abuse? What does it mean to budget with people who don't have much finances? How do I balance the needs that people have to have public resources and to have an income? how do I talk about this in a meaningful way with survivors? And I didn't get that. So I went back to get my master's degree in social work, and then started after that to work in a program in St. Louis, Missouri, where we specifically were working on the intersection of intimate partner violence and economics. So we did an economic education program for survivors wherever they were, and also did economic advocacy. And so that informs this work that I've been doing ever since. I do a lot of working with other social workers and advocates to talk and think about these issues. And that's what we're going to do today. So I feel like I have one main goal today, which is to convince you of three things. Number one, that economic work is essential with survivors. So I want to let you in on why I feel like this is true. So here, I'm going to give you the three things I want you to learn today. So I want you to learn that economic work is essential with survivors. Number two, we are the right people for doing economic work. And number three, how we do this work is important. So those are the three things I want to make sure we learn today. And in addition to that, we're going to talk a little bit about economic safety planning. So that's a lot in an hour. We'll see where we get, right? So why is economic work with survivors essential? I'm sure you're all yelling at your screen about, yeah, you know that this is true, right? We know that number one, abusive partners' behaviors specifically target survivors' financial agency. They specifically target their ability to make choices around their finances. Number two, we know that having limited resources, especially for survivors with targeted identities, put them at a greater risk for violence. And number three, survivors in the court system specifically have costs associated with their pursuits of legal remedies. So I'm going to talk, ground us through a story. This is a story of somebody named Sonia. We don't have a lot about Sonia, but I'm going to share with you what we do know about her. I'm also going to put in chat a link to her story on Google. So if you want to look at the Google Doc as I'm reading it, you totally can. So this is, we're going to talk about Sonia. I'm using you as the article so that we can get into Sonia's mind. Okay. So you are Sonia right now as I'm reading this. So you just got off a swing shift at a skilled nursing facility where you work as a certified nursing assistant. You're a 32-year-old woman who describes yourself as a hard worker and a dreamer whose life took a turn I wasn't expecting. In the past 5 years, your husband, Robert, has become increasingly jealous and doesn't want you to go anywhere except work and your children's school. You have 2 kids, Danny and Samantha. Danny's 9 and Samantha's 7. Danny has autism and is nonverbal and requires a lot of care. You advocate hard to make sure Danny gets his needs met at school. You're a first-generation American and you grew up with parents who are from Mexico and who speak solely Spanish. Robert has forced you for years to have your paycheck directly deposited into a banking account that you can't access. You think it might be a joint account, but you aren't sure because he's never given you an ATM card or a debit card. You're also very upset because you just received notice that you are being sued by a credit card company, but you didn't know you were. You recently found out that Robert has not been paying the mortgage consistently, and you've received some kind of notice from the bank, but Robert won't show it to you. You're worried you could lose your home. You love your job and get a lot of good feedback from your coworkers and supervisors, but lately, Robert has been bothering you at work and accusing you of sleeping with a coworker. He calls you and texts you a dozen times during your shift. Yesterday, Robert showed up at your workplace loudly yelling your name at the front desk as he came in. When you confronted him about it at home, he pushed you and called you names. He only gets physical every once in a while, but it does scare you when he does. So that's Sonia's story. So Sonia comes in and we are knowing that all those things are going on for Sonia. But as an advocate, we oftentimes don't have all that information as we're sitting face to face. So I want you to think about just for a minute, what do you think Sonia would actually share with you if she knew you were a domestic violence advocate? What parts of her story would she share with you? What would she think was relevant to the conversation that you would have together? also want you to think about, what do you think would be Sonia's greatest financial concerns? What are some of the things that she might be worried about? And then what do you think she could use help with financially? Just letting you think just a moment. So anybody want to share what you think, what Sonia would share with an advocate? What do you think she would tell people? I'm not sure, and we don't have Sonia in front of us, so we don't know exactly, but my experience often is when we're talking about domestic violence, exactly, thank you, Elizabeth. Elizabeth said that she would share that she was pushed and called names. What we find is oftentimes survivors will tell us about the things that they think are about the domestic violence. So they'll tell us, like Elizabeth was saying, about the physical violence, about the emotional abuse. And then some of the financial worries, like the worried about losing her job, worried about losing her home. And so we may get pieces of that, but she'd probably start her story out with the talking about the pushing and calling names. Sylvia also talks about she may be worried about custody and visitation. So we don't even know why Sonia's coming to talk with us, right? Oh, Natasha's saying yes, that Robert hasn't been paying the bills. So there's all that's going on with her. So it could be that she talks to us about the physical sexual violence, the economic abuse, the challenge that she has that her child is neurodivergent, her workplace safety, employment, housing issues, childcare. So when we think about what's happening for Sonia, all of those risks are out there for her. She's concerned about what's going on for her. She has a lot of risks in her life. And so when we ask this question of what does Sonia need to feel safer, we could think of a million different things that we could do, that we could work on, that we could think about to make her feel safer. And one of the things that I like to talk and think a lot about is that none of us can guarantee ever that anyone is going to be safe. Nothing we can do will guarantee anybody's safety. And what has oftentimes happened within the domestic violence movement is that we have prioritized the physical violence or the emotional abuse and not as much paid attention to the economic pieces. And when we're talking to people that we're working with, what we know is that many times actually their economic safety may be paramount in their mind about what they're concerned about. They may be more worried about having a house over their head than about the physical violence that they're experiencing. And what happens is, if we respond when we hear about this violence, is saying to Sonia, right, when we're hearing about this, well, we need to get an order of protection, or an order of protection is probably going to help you, or we need to figure out how you can, get to safety. We are probably not listening to Sonia to actually ask her about what it is that she would like to work on in terms of what it is and what safer looks like for her. So I want to take a step back for a little bit and talk a little bit about the idea of economic abuse. And for a lot of you, I know in this space, this may be something that you've already thought about and talked about a lot, but it's always helpful for us to all get on the same page in terms of definitions and what we're talking about. Because when we look at what's happening for Sonia, there's a lot of economic abuse going out there. So one of our foundational researchers in this area is Adrienne Adams, and she did a really pivotal study that was really important for our field back in 2008. And what she found when she was talking to survivors who were experiencing intimate partner violence and started asking about economic abuse, she found in that study that 99% of survivors were subjected to some form of economic abuse at some point during their relationship. So if you're sitting across from somebody, there is a huge likelihood that that person, as a part of the violence that they're experiencing, has experienced some sort of economic abuse. So we're going to define that today. This is a little bit of a shift from Adrienne's language, but it comes from her original research. That economic abuse it can be defined as behaviors that control a survivor's ability to acquire, use, and maintain economic resources, threatening their economic security and their potential for economic agency. So we oftentimes think about economic self-sufficiency, and we're going to shift our thought there. And what we want is for survivors to have economic agency. So self-sufficiency always kind of, to me, makes us focus, think like we can do this on our own. And none of us can survive economically on our own. We all need other people. We need our jobs. We need our friends and family at times. We need help understanding concepts. And so I think what we're working towards is more that survivors have agency, which we have a wonderful definition with CSAJ that talks about agency being that is a survivor's capacity to direct the course of their life, not only having the skills to navigate inequitable systems, but also to have meaningful access to economic resources. So that's our goal within CSAJ, and I hope all of our goals as we're working with survivors is to get towards economic agency. And part of understanding that is how are abusive partners getting in that way of us, of survivors getting to do that. And we can think of it in two ways. Number one, through the abusive partner may do economic restriction, which would be placing limits on the survivor's economic resources. So I'm sure you all can think of some examples from things you've read or survivors that you've worked with over the years, but this might be things like interfering with income production. So not allowing someone to work, or like we saw in Sonia's case, showing up at that person's work, which may interfere with that income production, right? It could also be hiding money, dictating spending, where money's being spent. Hiding money, that's another thing we see Robert doing in this situation with Sonia, because Sonia doesn't know where that bank account is. It's her own money that's being deposited in that bank account, but she doesn't know how to have access to it. She doesn't know what the mortgage information is. So he's hiding a lot of information from her within that. So I'm sure you can think of economic restriction with folks that you've worked with before. We also see this in economic exploitation, which is using the survivor's resources for one's own advantage. So this would be things like spending the survivor's money. So I don't know about you, but a lot of times I see this. I forgot to mention earlier, I'm also an advocate. So I work at a domestic violence hospital, hospital-based domestic violence program right now. So I also work with survivors. And I just think a lot of the people that I work with, is even working with somebody yesterday whose all of the bills are in her name and all of the assets are in her partner's name. So trying to figure out like how this looks for folks. This also can be part of the thing as and Guru was talking about earlier, this idea of creating debt in the survivor's name. And this is what we call coerced debt. And we see this in the situation where Sonia is receiving some sort of information that she's being called to go to a court hearing about something. She's being sued by a credit card company, but she doesn't know about the debt. So it may be that Robert has opened credit cards in her name without her permission. And we see this a lot. And it's once you have an intimate partner, you know their social security number, you know their maiden name, you know so much information about them that it's very easy, especially now, to get online and to open up credit cards without that person ever knowing. Now it's illegal, they're not supposed to do it, but people do it all the time. And so just want to acknowledge that. And it could be also stealing money or property. Oh, and Natasha also talks about, yeah, Robert hasn't been paying the bills, but also not telling Sonia about not paying the bills. And so maybe putting her at great risk by not paying the bills and by doing that. So thank you for bringing that up, Natasha. Anything else that you saw in terms of economic abuse, either economic restriction or exploitation that you saw in the story? Right, I guess we covered them all. So not only do we need to, I think, be doing economic work because abusive partners use economics as a part of their power and control, but also because there are risks associated with having economic challenges for survivors of intimate partner violence. So we know that economic challenges in people's lives lead to greater risk for them, greater risk at homelessness, greater risk of having severe mental health problems if you're not getting access to healthcare, risk of not having the resources for healthy food and feeling healthy in your body. and not getting transportation, childcare, all of the things that are associated with poverty. And when you add the risk of intimate partner violence on that, we know that survivors are at greater risk. So this is a wonderful visual that came from CSAJ that really shows this connection between poverty and vulnerability to violence. So we have research that shows that the risk of domestic violence to all women is about 25%. About one in 4 women are at risk for experiencing domestic violence. And this research was done on very binary research. So it just was looking at men and women. It didn't look at trans folks or non-binary people. So it showed 25% of all women experience intimate partner violence. But when we look at homeless women, we see that 50% of homeless women have experienced intimate partner violence. And then when we look at women who are receiving public welfare, so thinking about TANF, that 70% of those women have experienced intimate partner violence at some part in their life. We know that survivors living in poverty experience violence at twice the rate of those who do not. The link between poverty and domestic violence is well substantiated. It's well substantiated by service providers, by you and I, we've seen this, but it's also by researchers and by survivors. We know that this is something that's really complicated to talk about within the domestic violence movement, because we don't want to say that poverty causes people to be violent. But yet we also know that poverty makes it much more difficult to leave an abusive relationship, to have other options, to stay, and the likelihood that someone is going to be in a relationship longer because of this lack of resources are much higher. So we know that there is this relationship that goes on that is very important for us to look at. And I think as a domestic violence movement, we've been scared about talking about this because we don't want to say people in poverty are more violent, but we also need to be looking at how violence and poverty really enmesh to trap folks into not having options and choices and not having that economic agency that we talked about earlier. We also know that other forms of oppression, racism, homophobia, transphobia, xenophobia, anti-immigrant hatred, all of this compounds poverty, and that we know that grinding poverty, just the inability to move forward with finances, leads to further trauma in people's lives. This is another beautiful visual from CSAJ. This is just looking at the intimate partner violence is linked to a range of negative economic outcomes, so that people that are experiencing intimate partner violence are also at a greater risk of experiencing job loss and income loss, housing instability, limited transportation, and decreased access to childcare. And this decrease in safety options leads to an increased risk of future violence. I think I already talked about this, but we just know that the intersecting identities really impacts, and targeted identities and oppression really impacts people's ability to have more access to money and power, and that can lead to greater vulnerability to violence. We also know that abusive partners are really, really good at understanding these vulnerabilities and to play on them. So to say things like, yeah, good luck leaving, you are never going to make it on your own. You have that learning disability, which is going to make it really hard for you to get a GED and get a good job. So you're going to need me, right? So that intersection sometimes with disabilities or other forms of discrimination that are going to further entrench this experience. We also know that there are costs being involved in the court system. And so, for example, it may be expensive to get childcare to come to court, or to get transportation to and from court, taking off time, or losing jobs, losing work to take off time. I had a survivor I worked with many years ago that she had taken for the last 4 years. She had an abusive partner that would not leave her alone. She had taken all of her sick and vacation time for court costs and had never had a time off that wasn't dealing with court systems. So we know that there are costs that are associated with being in the court system. And I'm just going to briefly go over this slide, but this was a research study done in 2015 that looked at the fact that just applying for an order protection had an impact on survivors' income and their projected income. So if you see this visual, you see that that people's income was slowly going up in the years before they petitioned for an order protection. And after they filed for that order protection, whether they got it or not, we see a flattening in their income kind of growth that accounts for about $1,000 within that year for folks. And when we think about that over a lifetime, this impact of being involved in the domestic violence courts, of having a partner that's increasingly or ongoingly causing problems for you at work and not allowing you to get your education, maybe creating some challenges with trauma, mental health challenges that are hard to deal with, that we see this impact of economics, not only in the short term, but in the longer term. And CSAJ Erica, who is, I think, on still, coined this really beautiful visual to look at this issue, to think about it as the ripple effect of domestic violence, so that we see that there are costs associated with domestic violence for people, not only during the relationship, but also as they're leaving a relationship in the short term, and then oftentimes in the long term. So we see this, for example, for survivors whose credit has been destroyed through an intimate partner, who may be using identity theft to open up credit cards in their name, that it's very time consuming and lengthy to deal with credit issues that may be impacting folks for years to come when it comes to their economic life and situation. So everything costs more if they're trying to get it through credit because of this abusive partner, because of this relationship. We also see impacts of employment where people stagnate or have challenges keeping employment as a result of the domestic violence. And so thinking about this ripple effect. So all of this I hope what I've done in the last little while is convince you that we need to be doing economic work, that survivors need us to be doing economic work, because the domestic violence itself is impacting their ability to have economic agency in their lives. So if I've convinced you of that, I've done part of my job. But my next part is I want to talk to you about how we do this work is really, really key. And this is what we talk about at CSAJ as being survivor-centered economic advocacy, which to us is really this ability to take a step back and to understand what is going on for their survivor, what their values are, what they want for their lives, what their risks have been from their partner, and what their goals are, what their vision is. So in my experience, a lot of advocates, our focus is to be survivor-centered, to have really survivors drive the work that they do. And it sometimes is, in my experience, a little bit harder to do this when it comes to economics. Sometimes it seems like there's a clear answer. And as advocates, we want to give that clear answer, right? That we maybe want to be like, no, you shouldn't do this, or maybe you shouldn't buy this, or you should put your monies here to be safer, or this is going to cost you less. And what I am hoping that we can talk about today is thinking about why that might be and how we can actually let the survivor drive our work together when it comes to economics. So to me, survivor-centered advocacy is putting the survivor's needs first. And that we are going to use some strategies from motivational interviewing, which is a way of being with survivors to help us understand what they need and they want. And then also to think about trauma-informed care. Oh, Jennifer, I missed what you said. I think I missed a few people in chat. I so apologize. Oh, okay. So Rosario was talking about, yeah, some people in their culture think it's normal behavior that the man should manage or control everything, including their salaries. Absolutely. So that might be part of somebody's experiences of culture. And so that their partner may even be telling them that's normal. This is how it should be. Men should be in charge. What I always tell people, and again, you can have your own opinions and think about this, is that everybody has a right in their own relationship to come to agreements about how they want to be together. And it is everybody's right in a relationship to decide that one partner has more control over the money or not. Like a lot of families with healthy relationships make that decision. What becomes abuse is when those agreements are only created by one person, when those agreements are not it's not safe for the other person to question the agreements or to talk about the agreements. And so what I hear you saying, Rosario, is that sometimes that's culturally derived. And if the survivor is okay with that part of their relationship, that's their own right? And we can also talk about like what if that is really what they want, or if that's what they're being told that's what they want, and trying to understand that and help people think about what for them does economic agency look like. And lots of times we see in situations where survivors will say to me, well, I was taught that men take care of the money, and that's the way it should be, and that was okay for my family because my dad was really generous with that and wasn't abusive with that. So my expectations is that was how my partner was going to be. But now I see this person restricting my ability to even have money to pay for shoes for the kids. And we talk about like, that's not culturally what was supposed to be taught. It wasn't supposed to be taught that one person is, abusive with the money, even if that one person has more control. So those are really complex, nuanced cultural conversations. I'm so glad you're bringing that up. And to me, that comes again to the survivor-centered conversation, is that we're talking about people's values and what do they want from their relationship? What do they want when they're talking about their finances? And their values may be very different than my values, which is why, again, I want to think about, have them drive what they want to get out of that. And as a cis white woman, I may have very different ideas about money, and have been taught very different things and have had different privileges and experiences than other folks that have different identities. So Jennifer also said some survivors don't have legal authorization to work in the US. Absolutely. It's so challenging to work with survivors around economics when there is not work authorization. We also see a lot of abuse by employers of survivors who do not have work authorization because they don't have legal rights to complain with that. So yeah, thank you for bringing that up. All right, so I'm going to briefly talk about this. Yes, and not have eligible for government benefits. Absolutely. Yeah. So that sometimes our economic advocacy looks really different with folks that do not have status and do not have documentation. And it oftentimes requires a lot of creativity and a lot of using community as a strategy. So thank you for bringing that up, Jennifer. So survivor-centered advocacy to me is really about creating partnerships with the folks that we're working with, that we're working together, and we're acknowledging challenges when it comes to power and partnership, and really letting, as I said earlier, the survivor guide the conversations about what they want and how they want to get there. I'm going to briefly talk about why I think that survivor-centered advocacy is so helpful. First of all, we have good evidence to show that it actually is very effective. So we see oftentimes organizations move towards kind of menu-driven advocacy about like, here's what we have. We have support groups. We can get you an order protection. We have a shelter. Here are the things that we can do, instead of asking first what the survivor wants and needs, and then we try to match those needs with our own advocacy. And there's been some research in this area, and that's found that survivors who work with advocates who use survivor-centered models have less difficulty getting community resources over time. They actually experience less violence over time. They have a higher quality of life and have increased optimism. So to me, it compels me to really want to start there and want to work with the survivors with what they have. So what this requires for me when I'm doing economic advocacy, it requires me to address a wide range of the survivors' needs, including their economic needs, with the goal of being safer. And that part of the work is that I'm trying to reduce the survivors' economic risks, as I said earlier, based on their values, goals, priority, and strengths. And it really focuses on increasing the survivor's self-determination, their ability to make choices about their own life within that piece. So I also, as I'm thinking and talking about money, I am thinking about this idea of trauma-informed care that we do, and understanding that many of us, based on living in our society, have a lot of trauma around money. Maybe we've had money taken away from us. Maybe we've had people in our lives that have stolen money. Maybe we've been told lies about different jobs. And we know that a lot of the survivors that we work with have trauma around money because of their own experiences. I know a lot of survivors I've worked with have had to have parents that use their information to open a gas, maybe utilities. And so when they become of age, 18, 19, they already have credit challenges based on their parents trying to survive. And so we have to kind of identify that money can be associated with trauma for a lot of people. Oh, look at, I already talked about that. So what we are, I think, compelled to do as we're doing economic advocacy and survivor-centered economic work is really be thinking about all these trauma-informed care principles that we are trying to resist re-traumatizing folks. We're trying to respond through the trauma principles, recognize signs of trauma, and most specifically focus on the 5 trauma-informed principles, which is having this wide view of safety, which to me earlier talks about not just looking at physical and emotional violence, but also economic violence. That we are trying to be trustworthy and transparent as we're doing our work with folks. We're telling the truth. We're telling them what we can do and what we can't do, and we're not opaque with that. We're very clear about what our role is, what we can do, what we can't do. We work in collaboration with folks when trying to give people empowerment, voice, and choice, and that we're really paying attention to these ideas of cultural, historical oppression and power, especially when it comes to money. So to me, survivor-centered economic advocacy responds to the trauma in partnership. It understands, as I said earlier, and I keep saying it over and over, it responds to the survivor's goals, values, and risks. It helps increase the survivor's skills and strategies when it comes to money, and it builds on those strengths and strategies they already have. And it focuses on reducing risks and building long-term advocacy. So how do we do this? How do we do this work? So I have already talked about how I want us to do it in terms of being survivor-centered, but what is it? What is economic work for survivors? What does it look like? And so sometimes we are going to be using strategies like motivational interviewing that I talked about earlier, which is going to be asking good questions about how to do this work. So we are going to start with this idea of economic safety planning, which is one way that we might be working with survivors around economics. So questions might be, how is economic safety planning different than general safety planning? Might be that, and I'll just give you a second to think. I'll give you a hint too. It's not, to me, there is not much difference. So what I'm trying to do is when I'm doing general safety planning and economic safety planning is understand this wide range of risks that survivors are thinking about, that those risks include not just what the partner is doing, but the other things that are worrying the survivor, the things that are making it difficult for them to get to that safer place that they want to be. So that when I'm thinking about economic safety planning, I'm thinking specifically about how is my partner impacting my ability to achieve or acquire economic agency? How is the survivor, how is my partner impacting my financial situation? And how can we work to reduce those specific risks within that? So when I'm thinking about, for example, thinking about Sonia and how Sonia might prioritize her risks, I don't know exactly for Sonia what she's identifying as the biggest risk for her right now. And if I made an assumption that it was the physical violence, I may be wrong because that was kind of the last thing she told us in the story. So one of the things, if I'm working on safety planning with Sonia, is I might be asking her, you know, as you think about your 3 biggest risks that just you cannot get out of your mind, the 3 biggest concerns that you have, what are those 3 biggest concerns? What are the things you're most worried about right now? And then how can we work to reduce those risks? What do you want out of our partnership? What do you, after we're done working together, how would you like your life to look? What do you want from this work together? And that can start grounding our conversations about money and our conversations about risk and how then we can think about reducing those risks. So part of that may be kind of figuring out how we're going to start having the conversations about money. Actually, I'm going to skip a few slides, so hopefully they can send the slides to you. I'll send them to Annette, and hopefully Annette can get them out to everybody, just to make sure that we have enough time. But we may be asking, so sometimes we don't know how to even start the conversations about money or economic safety planning. So this is just an example of something we might say, and you may have completely different words that you might use as you're trying to sit down and talk to a survivor about their financial situation. But I'm going to read this out loud. So as I'm getting to know what's happening for you right now and hearing some of your needs and challenges and trying to determine the best way for us to work together, it would be helpful for me to understand more about your situation with money. In my work with other people who have challenges with their partners, I've learned that oftentimes their partners have made their situation with money worse, and that has made them feel less safe. I'm wondering if you feel comfortable with me asking you some questions about your situation with money. So kind of prefacing some of that, if you don't feel comfortable just jumping into those questions. As I said earlier, I kind of usually just start with what are your biggest concerns, and then I see how those are related to finances. I may actually then say, as I'm hearing you say this, you're talking about childcare. I'm wondering how your childcare situation impacts your financial situation right now. How is your partner involved in your childcare situation? Tell me more about that. And then we can start looking at finances from there. CSAJ has a cool tool called Starting the Financial Conversation. Maybe somebody could, and Kuru, would you mind dropping it in chat for me? I didn't get the link here, I don't think. Or maybe I do have it. But we'll give you all that link because I think it might be helpful if you're looking at kind of doing this work and wanting to figure out how you're going to start these conversations. Here's just, again, some more examples about like what you might want to ask. When you think about challenges with money, what are the ones that worry you the most? What challenges do you want to work on first? So asking some questions like that. When it comes to economic safety planning, I really am going to have these guided by the range of risks the survivors identifying, the fears and priorities that they have in their own life, their goals, what they've already tried, the resources that they have, and what their values are. So another thing that I experience a lot when I'm working with folks around trying to talk about safety planning or economic work is that we oftentimes don't ask survivors what they've already tried. So then when we start safety planning with them, we say, have you tried this? Have you thought of that? Instead of saying, tell me what you've already tried. What has worked for you? What hasn't worked? What would you be willing to try again? Because then we're just like building on these things that they have already worked on and thought about. And I want to understand, as I said earlier, I want to understand the risks that they are most worried about so we can start working on that. And I like to do that sometimes with, and this is another motivational interviewing skill, is that I want to check for people's readiness about doing a certain thing. So, you know, for example, if I'm working with the survivor and they say, I'm really worried about my credit and I want to pull my credit report and look at it. And I'll say, you know, as you think about like all these things we put on your list, and getting your credit report is one of those. And you're really weighing and thinking about this. On a scale of 1 to 10, how ready do you feel to pull your credit report? And then we can kind of talk about that, you know, tell me why you're a 7 and tell me why, you know, why you're a 7 and not a 5. But then people start talking about like what it is they want to do, why they want to do it. And I start understanding within that. That also helps me understand the survivor's values. What do they value about what they want to get done? What strengths do they have to help them with that? So to me, economic safety planning is often concurrent planning. We're working with that survivor to figure out what they want for their lives and how they're going to be economically safer while they're doing that. So it may be at the same time working on a plan for while they're staying with their partner. If they decide that they are going to flee from their partner, if they have to flee in an emergency, if they want to leave their partner. So to me, fleeing and leaving are two different things. Fleeing is leaving in a hurry because of a increased crisis. Whereas leaving is a planful kind of strategy. Maybe I'll say in 3 years, once my kids are grown up, I'm going to leave, and here are the things I'm doing in the meantime to get me there. And that may be part of that concurrent planning is talking about separating and divorce. So if we talk to Sonia at her time that we're talking to her, she's still with her partner. We don't know whether she wants to leave her partner or not. That might be part of the conversation that we have with her. And so we would want to be understanding, what are Sonia's biggest concerns? So as you're talking to her, Sonia might say, well, my biggest concern is making sure that my son stays at the school where he's at, because he's getting all the needs he gets there. So I really need to stay in this school district. My second biggest concern is about the house. I'm really worried that we could lose the house without, paying this mortgage. And my third biggest concern is my job. I need to keep my job. So those three things are what Sonia wants to work on. And if we start from there, we can start asking questions. How is Robert impacting those three different things? And so if I started working with Sonia and said, hey, Sonia, it sounds really unsafe with Robert, let's try to find you a shelter. Or let's get you an order of protection. I would not at all be hearing what Sonia was wanting and what some of those concerns were for her and how economics might be playing in that. And maybe Sonia does want to leave Robert eventually. Maybe that's in a year after her kid leaves that school, so she has some more flexibility. Whatever it may be, I'm trying to listen and plan concurrently about those different things. So partially when people are still in the relationship, we're thinking about what can we help the survivor do to reduce their economic risks while they're in that relationship. So is that hiding money? Is that talking to people about what you might need and how you might need it while you're in that relationship? Is it bartering for goods or services? Is it increasing the survivor's knowledge, skills, and resources about money or what they could do while they're with that partner? Would it be trying to get copies of financial records or identity documents and putting those in a confidential location? Focusing on kind of if that person's doing things like hiding money, how do you think your partner would respond if they found the money? What would be your story? How would you respond? So always trying to decrease risk as we're talking with the survivor and they're trying to plan. So as they're staying, they may be doing that. As they're thinking about fleeing, these are the kind of typical strategies we think about when we're talking about safety planning oftentimes, is having a plan where that person might stay, thinking about money or documents that they would need to get. Do they have a credit card? What does that look like? Does their partner have one? What are the things that they would need to leave in a hurry, and kind of getting that prepared for them? If we're thinking about leaving plans can be short term in terms of 1 week to 1 month. Medium would be several months, or a long term. That staying plan may be reducing the risk. So we might be carefully and planfully trying to get financial documents and looking at what that might be. We might be creating financial resources, money banking. I've had survivors who have opened their own bank account while they were planning on leaving and not told their partner about that, and started siphoning money off in that account. And survivors are so creative about different strategies that they can think about while they're doing that. I have a survivor, I've told this story for years, but I just thought it was so creative, where she had her boss knew what was going on, and he wrote a letter that said that her insurance costs were going up. And so they automatically withdrew more money from her paycheck, and part of that went into another account that her partner did not know about. So she was able to save that money and be able to leave. Thinking about kind of what would it look like while you're with the partner to do things like freeze your credit. So one of the strategies I've used with survivors a lot of times is they'll say, I went to this identity theft workshop, and I heard that it's really better for everybody to freeze their credit. Let's do that. So what they might be doing is keep protecting themselves from their abusive partner, but their abusive partner doesn't realize that. They think it's from the outside issues of identity theft. So there's constantly things that we can be doing as we're thinking about doing economic safety planning. What I kind of think of it as like shining the spotlight on economics and how the economic situation is impacting the safer of that survivor in all the different realms of their opportunity. And to me, once I have kind of gotten into this idea of like economic work is essential, work with survivors, I can't have it's almost impossible for me to have any conversation with survivors about safety planning without talking about money and how we're working on that as a strategy. So I kind of think of the safety planning as some of the work that we're doing with survivors. But it's not the only thing that, oh, I didn't talk about separation or divorce. Separation or divorce may also be a part of our safety planning and thinking about what are the needs that folks have around those documentation, who could be lawyers, what kind of information do we need. It may be a part of our economic help there might be looking for legal assistance with separation or divorce. So to me, that this idea of economic safety planning is a piece of the work, but part of it is also doing this targeted economic advocacy with people. So we're using the information that we've gotten from asking questions for folks about what is working for them with finances, what their values are, what their goals are, to then craft strategies around economics. So it might be, if I said earlier, I'm working with Sonia, and Sonia doesn't know what's happening with her credit. We would be working with Sonia to say, do you feel comfortable pulling your credit report? Do you think Robert will know that you've pulled your report? How do you think he would feel if he saw? So if we pull her consumer report, what information would that give? Could we work on credit advocacy in terms of disputing some items? How could we get information from Robert? What might be stories she could tell to Robert about how she might need information about the mortgage? Is there ways that she has rights around what her mortgage is? So letting her know what her rights are, trying to find information about, are they both on the mortgage? Are they both on the deed for the house? So doing this economic work that may be really tailored to the needs of Sonia or all of our clients. So this is like the next phase of that work. So we're doing the economic safety planning, and then we're doing targeted economic advocacy work. So I told you I'd try to convince you of 3 things before you left. Number 1, that we should be doing economic work. Number 2, how we should be doing it, so survivor-centered work. But number 3, that you are the perfect person to be doing economic work. So most of us did not come into this field because we just were really good at money management. We're really good at like helping people with economics. Some of you probably are super good at that, but it's oftentimes our passion that comes from working with survivors. And we oftentimes question our own economic strategies or our own economic prowess to make good economic decisions. But I really think that advocates are the perfect people to address values, strengths, concerns, and power when we talk about economics. So what I would encourage you to do in the next little while is to kind of think about what are some of the things that for you may be getting in the way of thinking about doing economic work? What are your values around money? What do you have to bring to the conversation? What I would say is that just like anything else in advocacy, we learn a lot of this by doing, and we don't have to know everything when we start. When I first started doing this work, I didn't know any of it. And by working with survivors, by getting in there, getting dirty, not knowing exactly what I was doing, asking good questions, finding good supports, that's really how we learn. And that we as advocates have the skill to do this. And I really, as you can probably tell, get excited about this. I think that we can make a world of difference for survivors out in our communities all over the country by doing really, really important, really hard, and really meaningful economic work. So I just spewed a ton of information at you. And I really enjoyed the 55 minutes that I got to talk with you. I'm hoping that this is just for you all a starting taste of economic work, and that as you are working in your organizations, if you have more questions, more ideas, more interest, that you will connect with CSAJ, and that you also would consider being a part of the cohorts, which I think Nkuru talked about earlier. If you have questions for me, I'll stick around for a minute. And also they'll have your email, have my email address if you want to follow up with any questions or want to talk about any of these ideas. But I want to give you a few minutes before the next presenter starts. So thank you for your time. Thank you for your amazing advocacy. And Miranda, do you have something you want to say? Saw you unmute.
Yeah, I'm just going to quickly tell folks that we're going to reconvene around 3:05. So Katie, thank you so much. And we'll see you all in a few minutes. Sounds good.
Hi again, I'm Jessie Minlin. I'm with the Victim Rights Law Center, and I'm presenting on 2 topics today. The first is on non-attorney legal advocacy, And the second, which will be in the second hour, is on providing legal assistance to survivors of non-intimate partner sexual assault. So I just want to start with a little bit about me and the work of the Victim Rights Law Center. I thought I would just share a photo that is me just before I head down on the observation tube. And I'm coming to you today from McMurdo Station in the Antarctic. So I'm on Ross Island in Antarctica. I'm doing sexual assault and harassment work, and I'll be back in the US in about a week, but I've been down here for about 6 weeks. And I think I might have a photo with some seals in the next presentation, I'm not sure. And then just briefly about me, I've worked at the Victim Rights Law Center heading on to 20 years and direct our Oregon office and then also our national TA work. And I'm part of a team of lawyers and legal staff, some of whom are pictured here. And we provide technical assistance to OVW grantees or to those eligible for OVW funding in sort of 4 key areas, 2 of which I've mentioned already. One is supporting the work of non-attorney legal advocates, supporting the work of lawyers who are representing sexual assault survivors, particularly with an emphasis on non-intimate partner sexual assault. We're partnering with the American Bar Association on a new TA grant around trauma-informed legal services. And then we're also one of the campus grantees providing TA in that realm. So you see, it's me that you might be seeing today, but I'm really just, one of many amazing lawyers and legal staff who do this work, who are just incredibly smart and passionate about what we do and also about what we do and how we do it. And then I've just I always feel like the term technical assistance is like only that's known by the people who actually do it. So it can be helpful to break that down a little bit. We're talking about providing just expert advice, individual case consultations, programmatic consultations, doing training, mentoring lawyers, particularly those who work outside of the more traditional legal services or legal aid context, and may often even sometimes be the only lawyer at their organization. We share our policies. We will review other folks, conduct legal research. We have a number of legal surveys where we've surveyed a particular law or set of laws for all of the states, the populated U.S. territories, Washington, D.C., et cetera. And I've mentioned a little bit about our TA work, but it's very much informed by the work that we do with our feet on the ground. The Victim Rights Law Center has offices in both Oregon and Massachusetts, where every day we're providing free legal services to survivors of rape and sexual assault. And it's, I think, one of the wonderful and really very unique aspects of our work as TA providers is that, we have lawyers in court doing intake interviews, talking with survivors, et cetera, just on a regular basis. And that infuses our work with, I think, just a really valuable perspective. So I'd love to just know a little bit more about you. What is your role at your organization? And if you would go ahead and launch some, thank you, TA to TA. Are you a legal advocate that is community or tribal nonprofit or other nonprofit organization based? Are you a system-based legal advocate? For example, do you work with law enforcement or prosecution or tribal court, a paralegal or a legal assistant? And then I'm just going to invite you, if you are in that other category, to share it in the chat so that we can see it as well. I'm not in the chat now. It seems like lots of technical difficulties today, but you all can share with each other at least. So I can see that overwhelmingly, almost 70% of you are lawyers, but we've got over 10% who are working as paralegals and legal assistant, and more than 10% also as a legal advocate. So thank you. And then next question, just for how many years, for those of you who are providing legal advocacy, for how many years have you been working as a legal advocate or doing advocacy? Always great to have a sense both of who's in the room and what you all do, and then also for how long you've been doing it. I always love watching those numbers go up. Somehow I feel so driven by like, oh, I want to get to at least 60% or 70%. So I can see that we're over 60, so yay for that. I'll encourage the rest of you to respond in the polls as well. Great, so lots of folks on this webinar who have been doing the work for a long time. Really wonderful to see. It's always just longevity in the movement is something that makes me very happy. So when we're talking about legal advocacy, when I've been sort of tossing this term around and using it without really kind of going into any kind of an explanation about what is it that I mean when I'm talking about legal advocacy and what are the differences between these various categories. So, there's advocate, legal advocate, paralegal or legal assistant, attorney, and I put paralegal and legal assistant together because oftentimes, depending on the organization, folks are wearing one hat or the other. I mean, traditionally, I think a legal assistant assists more with administrative tasks as well as a sort of more of a paralegal. But that, again, it just really depends on the organization, the firm, et cetera. And then, of course, this difference between advocate and legal advocate, which is a little bit artificial in the sense that there are many advocates who engage in legal advocacy also. But for the purposes of this presentation, when I'm talking about advocates, it's that full breadth. Right? Advocates may facilitate support groups, may help secure emergency or transitional or long-term and permanent housing for survivors experiencing houselessness. They may even be doing individual counseling or running a children's program at a domestic violence or other shelter. Whereas when I'm talking about legal advocate here, it's specifically those who are non-attorneys in this context and engaging with the criminal justice system, the civil courts, it could be tribal courts, it could be on the immigration side, in particular, federal courts, et cetera. So there are many different kinds of courts and many different kinds of assistance that, in fact, legal advocates may be assisting with. So I can see someone said advocate, and I'm going to invite you just to share in the chat box in what kinds of matters, for those of you who provide legal advocacy, where are you providing it? What kinds of topics, cases, practice areas, survivor needs are you doing? And I'm going to be specific here, legal advocacy. You said they're an attorney, protection orders and family law cases, immigration. Invite you to keep posting up more immigration, domestic violence restraining orders, CPOs, now landlord, tenant, and consumer work, guardianships, victim rights. It's a really broad array. That's wonderful to see. Evictions, so a lot of protection orders and family law. So I just kind of made a list here, both of the kinds of courts in which non-attorney legal advocates might be advocating for survivors, so criminal, and I want to distinguish there both between adult and juvenile, which sometimes is completely separate and sometimes there's a fair amount of intersection. Civil, administrative, so public benefits, SSI, SSDI, of course, there are tribal courts because tribes are sovereign nations. State courts, et cetera. And then again, just many of these topics that you already identified. I think there were a few that I didn't see on the list, such as crime victim compensation, was not on there. Education matters. I know that's a really large practice area at the Victim Rights Law Center, in part because of our focus on sexual assault, and we know that most sexual assault survivors are victimized between the ages of 12 and 24. And also I mentioned both Social Security and Social Security disability income. That's the SSI and SSDI. Just wanted, I threw this in here, just not going to spend a lot of time on it, just wanted folks to know that this is one of the many, many resources that the Victim Rights Law Center has created. This is just one page of it, but it's several pages long, and it's a document that just summarizes some of the key differences between the criminal justice system and the civil legal systems. It might be helpful to advocates who are new to doing the legal advocacy work, to lawyers who are new to lawyering, to explaining to survivors about the differences between the two systems. So please feel free to just shoot us an email right after this. It's ta@victimrights.org is our email address. And I'll put that in the chat. It's ta@victimrights.org. Victim is singular, rights is plural, one victim, many rights. And we have a voluminous amount of resources, literally like notebooks full. So when we're talking about non-attorney legal advocates, one of the important issues that we also need to be addressing and considering is the unauthorized practice of law, which I'm going to just abbreviate as UPL. And I'm often asked, well, like, how do you explain it? And I'm guessing that with so much experience by the folks on this call, you all may have your own shorthand for it. And what I usually just say is it's applying the facts of a particular case to the law. So I can tell someone what the law is, they can tell me what the facts are, but when I start applying the law to their facts, I'm essentially engaging in legal analysis and in the practice of law. One thing that folks will often say when I say, well, I can't give you legal advice, maybe because I'm not admitted to practice in their jurisdiction, or I am, but I can't represent them because of how our funding restrictions work. They'll say, well, I just want to give you a hypothetical. And I always kind of just want to put out a word of caution there, because when someone is asking you about a real case, but they're saying, well, let's just make this a hypothetical, and you know and they know that this is a real case, I think that you begin to be treading into some problematic area. I mean, this is not specific, just FYI, to the unauthorized practice of law, but it's always something, in particular, when we're thinking about UPL, I think it's important to mention. There's also some guidance I want to flag in the model Rules of Professional Conduct, or RPCs, that specifically address the responsibilities of a lawyer and also for managing attorneys or those with supervisory responsibilities regarding the work of non-lawyers in their organization. And not every jurisdiction has adopted the model Rules of Professional Conduct. Some have adopted them but adapted them, so it's a modified version. And some have adopted the rule, but not the commentary. But whenever I have a question about, well, what's in the scope of practice, or what's allowable, or what's unallowable, I always really will go to the model rule and also to the commentary, because I find it very helpful. So model rule RPC 5.3 sort of basically says two things: that if it's a lawyer having direct supervisory responsibility, and also those with managerial authority over the non-lawyer, have to make reasonable efforts to ensure that the non-lawyer's conduct is complying with the lawyer's professional obligations. In other words, like a legal assistant or a paralegal or a legal advocate who's being supervised by an attorney and coming under the umbrella of that attorney's legal license, you must make reasonable efforts to ensure that they're not doing anything that you as a lawyer may not do. And second, if that non-lawyer does engage in conduct that would violate the rules of professional conduct, then as a lawyer and their supervisor, you're responsible if you either knew about it, you ratified it, or you fail to take some remedial action to either avoid it or mitigate it at the time. And there's lots of other just helpful, I think, articles on the ABA website that you can access, which, again, whenever I have questions, I'm always like, I'm just going to go right to the RPCs to start with. So I want to give you a scenario. Yasmin is a legal advocate at the local domestic violence and sexual assault program. She conducts initial intakes and routinely helps survivors get civil or criminal no-contact orders in sexual assault, stalking, domestic violence cases. Frida comes to Yasmin for help with safety planning. Frida is limited English proficient. She's terrified for her safety, and she wants some kind of a no-contact order before the court closes at lunchtime for the long holiday weekend. Frida doesn't know what kind of order she wants. She has no idea what to write in the application. I'm going to give you 4 choices. What's the best approach for Yasmin to take in this situation? You go ahead and launch the poll. I'm waiting for TA to, oh, there we go. Right, I can see it doesn't have the whole set of questions, so, excuse me, set of options, so I'm going to read them to you. Option A, time is, no, this is the, sorry, TA to TA, you're on poll 3, and this should be poll 2. All right, hold on, everyone answering it. See if we can get the right poll up there. Close this one. While they're looking for the right poll, I will read you the options. Time is tight. Yasmin should choose the order that she knows Frida is eligible for, fill out the form for her, and tell Frida to take the forms to court right away by herself. Option B, Yasmin should explain the relevant laws, explain how they each apply to Frida's situation, and then let Frida decide what to do next. C, Yasmin should tell Frida that she cannot give her any information regarding the different kinds of no-contact orders, but that she can go to court with Frida to support her. Or D, Yasmin can tell Frida about the different orders and what they each require, but decline to advise Frida regarding which kind of order to apply for. And she can also accompany Frida to court. Oh, I see a note, Annette say, all right, no problem. The poll was missed. I'm going to invite people then to say in the chat, which one would you choose? A, B, C, or D? And lots of D's coming up. Great. Okay, you all got that one. I'm seeing lots and lots of D's. Perfect. Yes, absolutely. That Yasmin can tell Frida about the different kinds of orders. She can tell her what the law requires in order to be eligible for each of those orders. She can tell Frida what scope of remedies or protections might be available, but she should not, as outlined in the other options, tell her which ones apply to her situations or fill out the forms for her. So almost the same scenario, except that I've mixed it up a little bit. Yasmin is a legal advocate and paralegal at local legal aid. And there she conducts intakes and routinely helps the lawyers, survivor clients, get civil or criminal no-contact orders in the same list of cases. She meets weekly with the lawyers supervising her. And so basically same set of facts that Frida wants the order right away, the court is about to close. Frida doesn't know what kind of order she wants or what to write in the application. What's the best approach for Yasmin to take in this situation? And again, here are your options. Time is tight. Choose the order, fill out the form, and tell Frida to take it to court. Explain the relevant laws and how they each apply. That's B. C, Yasmin should tell Frida she can't give her any information regarding the kinds of no-contact orders that can go to court. Or D, she should tell Frida about the different orders and what they each require. Help her choose and complete the petition, and then on the way to court, text her supervising attorney, to update them on what she, Frida, is doing. So I'm going to invite you again in the chat. This is probably a little bit more difficult for folks. C and D, I'm seeing. Lots of C's. The B, I love it when there's all different ones. Right, or C. So I always joke that every lawyer's answer is, it depends. And I'm going to say it depends because if you're a lawyer, really you could do any one of these as Frida is your client and you're advising them. But in this scenario, let me just go back for a moment. We've made Yasmin the legal advocate and the paralegal. She's routinely engaging in this kind of assistance. She's meeting weekly with a lawyer who's supervising her. And also, admittedly, on the way to court, which is concerning, but that's when she notifies the supervising attorney about what she's doing. I would say if you are a legal advocate and paralegal, I might be inclined you could maybe do B because you're routinely doing that and consulting and being supervised by attorneys. I probably would not choose C. You're saying, telling Frida you can't give her any information because you can, in fact, even if you weren't being supervised by attorney, but you could definitely give some information about the different kinds of no contact orders. And in this case, I would also feel comfortable with D. It's not ideal. It's not what scenario I'd want to find myself involved in if I were supervising someone. But given the fact that Yasmin is doing this, she's doing it routinely, she's doing it under the supervision of an attorney with whom she's meeting regularly, I think D is also a possible option. So just kind of a recap, and I put state court here because rules in tribal court are just so different because tribes are sovereign nations and they can make their own rules. But so, and also in federal court you have immigration court, and you can be a non-attorney who's authorized to appear under the Bureau of Immigration Affairs. So that's the sort of state court caveat. But generally, kind of the rule is it's only lawyers. It's not paralegals, it's not legal advocates, it's not legal assistants who can appear in court on behalf of a client. And I think the operative there is sort of that client pseudo-attorney relationship. You can certainly go to court as an advocate, but as non-attorney, you may not offer specific legal advice. You can't be applying the law to the facts of someone's particular situation. You may not conduct settlement negotiations or draft legal documents. You may not sign papers to be filed with the court or ask questions at a deposition. I think a lot of those are pretty obvious, but it just can be helpful to recap them. And that also there's certain activities that are not typically considered the practice of law, which are filling in the blanks of a standard form contract, and then preparing tax returns, which I know some of you who are doing economic advocacy or bankruptcy or other kind of consumer law may in fact have somebody who's not an attorney assisting within your office. And then last but not least, just again that caveat to make sure that the lawyers aren't getting in trouble, which is that you may not help someone who's not a member of the bar do something that non-lawyers are not allowed to do. I want to turn for a moment to the foundations of legal advocacy. And again, I just want to hear from all of you. What would you describe as the foundations of doing legal advocacy work with survivors? Refreshing my chat. One of the things about being in Antarctica is that we have slow internet. It's something like the speed of 2 cell phones supports the entire 1,000 people on station here. I'm looking for, in the chat box, what would you say are the foundations of non-attorney legal advocacy? Just moving along. I'm going to offer that there's three things. Promote survivor privacy, promote survivor safety, and promote survivor agency and autonomy. So what do I mean by that? I'm just going to spend a few moments talking about survivor privacy in the context of VAWA confidentiality, since everybody on this phone call is receiving OVW funds. And again, this may be familiar to some of you. Hopefully it is familiar to at least a little bit to all of you. But I'm just going to remind you that if you have any questions about anything that I'm covering or want to just follow up and discuss it in more detail, just shoot us an email at ta@victimrights.org or put it in the chat, because I can obtain the chat later and follow up with you. So the starting place around survivor privacy is that grantees and subgrantees may not disclose or reveal any personally identifying information about someone who sought services from a victim service provider, received services from a victim service provider, or was denied services, unless one of three exceptions apply. So your starting place is you can't reveal anything personally identifying if they sought, received, or were denied services. And what are those three exceptions, or the three circumstances in which you can provide that information? They are, number one, written and informed consent. And I'll talk very briefly about what constitutes informed consent. It must be disclosed subject to a statutory mandate, or third, subject to a court mandate. The court order may be a court mandate, statutory mandate may be in a number of jurisdictions. Even lawyers are required to report, for example, child abuse or the abuse of an adult with disabilities or an elder or other vulnerable adult. These are the only three exceptions in which you can reveal the personally identifying information of anybody who sought, received, or was denied services. So what's required for the informed consent? And the nice thing about being OVW funded and having this requirement is that there's both a Code of Federal Regulations and a U.S. Code of Statutes that tell us exactly what's required for informed consent. The first is, and I have that acronym there, which is that it must be discussed between you and the person whose permission or consent you're asking for. There has to be like a meeting of the minds. You have to agree on what information will be released and why and to whom and for what period of time. And then there has to be a record or a recording of that agreement. And that's where the releases of information are so helpful. It must be in writing, so it must be signed and in writing. The release of information has to clearly define what information are you authorized to disclose or to share. So a clearly defined scope. You may not have blanket releases. You may not have a release that basically says, I authorize my legal advocate, or I authorize my attorney or my whomever to share whatever information they want. That's not informed consent. You cannot have a blanket release, and it must be time limited. And in terms of for what period of time, it really depends on what's reasonable. It could be a release that's good for 24 hours, that's good for a week or a month. If you're working in an immigration case, and those will often go on for 2, 3, 4, 5 years, you may decide that it makes sense to have it for a much longer period of time. Although I will let you know that in our office, in our practice, we limit those releases typically to 6 months, even in cases that we know are going to go on for quite a number of years. Because having to check back in with the survivor and make sure, are you still okay with me releasing this information? Have your circumstances changed? Do you still feel safe having this information shared? Is this even still a good contact phone number, contact email address for you? So it's really, I think, great to use these time-limited releases as a way to ensure that you are fulfilling all of the obligations that you want you and your organization to be meeting. That it must be revocable, it must be able to be canceled by the survivor, and as importantly, that you may not require a survivor to sign a release as a condition of services. It may be that there's certain services you're not able to provide if they don't sign the release. So for example, if someone is asking for their case to be staffed at a coordinated community response meeting, whether that's like a START team meeting or a domestic violence reduction team meeting or something like that, but they're not authorizing any information to be shared, obviously you can't then necessarily staff that case with any kind of detail that might become personally identifying. There might be other ways of staffing it that are not involving the sharing of PII, or it may be something that can't be done. But that doesn't mean that you wouldn't provide any services. You would offer them other services. The other thing about having someone sign a release is that you want to make sure that you and they are informed as to the implications of authorizing that sharing of information. So you want to be familiar not only with your own reporting requirements, for example, but also of those with whom you might be requesting or revealing information. And so, for example, let's say you get a release to talk with the survivor's mental health therapist or their physician, and the survivor that you're working with is a minor, and you might not be required to report abuse of a child, but those individuals might. And so part of getting that informed consent is making sure you're having that conversation where they know that if they authorize you to share this information, it will trigger a release of their information in terms of law enforcement or to adult or child protective services or whatever the agency is. And again, just a resource that we have, some folks, you can adapt it to your own jurisdiction, but it's just a chart that we created for across the top of what are the categories in your jurisdiction that trigger a mandatory report to law enforcement or to another government agency. And then who are the folks, those are the ones going down this left side, to whom you are often referring, or even infrequently, but perhaps regularly, making referrals or sharing or requesting information such that you could be inadvertently triggering a mandatory abuse report. And the reason in that last category is non-accidental injury, and the one right next to it, danger to self or others, and it's sometimes also referred to as risk of harm. The risk of harm and danger to self or others often applies to psychotherapists, mental health therapists, and the non-accidental injury to healthcare providers. And again, if you want a copy of this, just shoot me an email, ta@victimrights.org. And we do have a poll for this because we saw it earlier. Here's another scenario. Deanna is an advocate for VAWA-funded Hopeful House, which is the local domestic violence program where she supports survivors in restraining order housing and criminal cases. She works closely in that capacity with police and prosecutor and their grant partner, who is their local legal aid office. VA's Victim Assistance Office calls Deanna and very concerned about a survivor who's not been showing up for court, isn't answering their phone, isn't returning phone calls. The hearing is set for tomorrow. Both the criminal and the restraining order cases will be dismissed if the victim no-shows. Deanna saw the survivor and knows that they were feeling very poorly yesterday. And she wants both the restraining order attorney at legal aid and also the prosecutor to know this. But Deanna does not have a current release. So how might you approach it? Without a current release, with whom may Deanna share information? And Annette, if you go ahead and launch the poll, that would be great. Your options are A, Deanna may share information with victim assistance. Excuse me. I have to just move this. With the Victim Assistance Office only. She may share with the grant partner, which is the legal aid office only. She may share it with both victim assistance and legal aid, or she may not share any information with either one of them because she doesn't have that written release. Remember, she's concerned about the order being dismissed and also about the prosecution not going forward, which she knows the survivor wants. What could Deanna do? Folks, just another moment. We're only at Oh, here we go. The number's going up 33%. Let's see if we can get some more engagement. Okay, I'm going to give you just like another minute to go ahead and vote. Deanna, do nothing and just sit on the information. May she share it with her grant partner who's legal aid? Can she share it with victim assistance? Or can she share it with both of them? Almost a 50% response rate. Let's see if we get a few more people, then I'll go ahead and close the poll. All right. So we had about 80% of you who got the correct answer, which is that Deanna may not share information with either organization because Deanna works for the local domestic violence sexual assault program. The reason that Deanna may not share victim assistance without a release of information is that sharing that information will be personally identifying about the survivor that Deanna is working with, and Deanna does not have a release to share any information at this point. And the same is true about why Deanna may not share information with a grant partner who's legal aid. Just because it's their grant partner does not, under the federal statute or the federal regulation, in any way authorize Deanna to be sharing information. So for those of you who are partnering with different entities, you know that you must have releases of information from the survivor, and they have to be executed with that informed and consent and in writing in order for the sharing of personally identifying information. Does it feel like an artifice sometimes when they know that you're working with the survivor and you know that they are working with the survivor? Absolutely, but that does not mean that you're authorized to share that particular piece of information or in fact any other information. So even if someone is a grant partner, they may not be sharing you may not be exchanging information with one another. And we have a number of pre-recorded webinars specifically on VAWA confidentiality and privacy, in particular when you have a victim services component within a larger non-victim services provider. Even within that organization, you need to have a release of information to be sharing information between components. So I'm not going to go super deep on this because we have lots of resources, but I just want you to know that they do exist. And just email me, TA@victimrights.org for that information. Also, we have at the Victim Rights Law Center just a number of different VAWA compliant releases of information. We have two examples here, one that we use as sort of a we use much of the time the one on the right, which has the much bigger font. You can't see the other parts of it, but it also has just some not stick figures, but some graphics that we use to ensure that our releases are accessible to folks who may have a lower literacy level or may have intellectual or developmental disabilities or otherwise be neurodivergent. And all of the releases that we have are VAWA compliant. We have them in English and in Spanish. We have some that are in Spanish only if they're just internal to us and we don't need to be sending them out to another organization. So again, feel free just to let us know if you want copies of any of our releases. And again, a reminder that they have to be in writing. So COVID notwithstanding, your releases of information currently are still required to be in writing. They may not just be verbal only. So I mentioned that there were sort of three components to survivor-centered legal advocacy. The first is privacy. The second is promoting survivor safety. And here, one thing that I really want to emphasize is that safety planning is a process. It's not static. I will tell you, get very concerned when I hear lawyers saying, oh, we just have the advocates do it, because it confounds me a bit of how safety and safety planning isn't a part of your legal strategy and isn't a part of your ongoing conversations that you have with survivors, particularly because where they are at the beginning of the representation or the beginning of their advocacy often changes and adapts and it morphs over time. And then again, depending on whether it's a survivor of sexual assault, intimate partner or non-intimate partner, stranger assault, domestic violence, stalking, dating violence, human trafficking, that the kinds of safety planning that the survivor needs is likely to vary widely, as well as on what are the remedies that are available in your jurisdiction. Is there a stalking order or is there not? Is there a general harassment order? Are there orders that are available specifically to survivors of non-intimate partner sexual assault, or are those civil protection orders only for those who are victimized by someone to whom they're related by blood or marriage or adoption? So there are many different pieces that will fit in. And again, we just have a number of different safety planning resources at the VRLC. We have just a few examples here, one that's safety planning with LGBTQ survivors of sexual assault, another that's specific to safety planning with adult survivors of non-intimate partner sexual assault, and then one that's very, very visually based, which is part of the work that we did with a long-term partner that was providing transitional housing to individuals experiencing houselessness. So we have a safety planning tool, it's in English and in Spanish, that specifically is safety planning with sexual violence survivors experiencing houselessness. And again, we can share that. There's also a kind of a, I don't know, documentary always seems like such a big word for it, but a video that we made by, for, and about sexual assault survivors experiencing houselessness. And there's a whole curriculum that goes with it, and you can access that through our website. I mentioned earlier that particularly in representing minors, that most sexual assaults are committed when it's survivors between the ages of 12 and 24. And most of those survivors, particularly on the younger end of that spectrum, are in school when the victimization happens. And so when you're talking about safety planning for those who are in school, there are many different facets to consider. If it's somebody who is, in college or boarding school or going to school abroad, where are they living? Where is their housing? Are they living in a dorm? Are they living off campus? What's their class schedule? And is that a time that they will be either physically and or emotionally vulnerable? How are they getting to school, from school? Is it a kiddo who's riding the school bus? Are they walking to school? And is that a time that there are safety concerns? Are there no contact orders available through the educational institution? What are their extracurricular activities? Are they engaged, whether it's before school or after school? Are they have practice? And where is that practice? And when they get out of practice, are they likely to, be very few people in the school building, for example? Or is it in a modular that's not near the main part of the school's campus? If you're talking about, adults or even just actually older teens, they may very well have a job, so you still want to be thinking about employment issues, even though you're representing a minor. And here's just an example of when we are doing safety planning with student survivors. We often will just sit down and have them map out for us, draw me a map of your school. It might just be one building, but it might be a larger campus area. How do you get there? How do you get between buildings? Which doors do you use? Are there alternate doors? What time do you eat lunch? Is there more than one lunch shift such that the survivor could be at one lunch period and the person who harmed them is at a different lunch period? Where is their locker? Do they have a locker? Where is it located? Where is it located relative to the entrances, or where is it located relative to the locker of the person who harmed them? And just also in the building, is it maybe way down a hallway that's not well lit, or where there often are not people after school hours, for example. So all of these are just some considerations when you're engaging in this kind of safety planning and wanting to do it in a survivor-focused, survivor-informed way. Which of course leads me to my third point here in terms of the foundations of legal advocacy, which is just that we always want to be promoting survivor agency. Let's see how we are on time. Nope, we were just about at the top. So I'm just going to invite you to think about it. What do you mean? What does it mean to you to be survivor-centered and survivor-led? And then what are the challenges to that? Particularly, I will offer with minors, where you often will have a parent or parents or guardian ad litems involved, even if they're not the parent or adult who is causing harm. And then I think particularly for those who have come maybe not out of the survivor-centered work, it can be challenging to think that you're really putting the survivor in control, that they get to decide what's best for them, rather than us saying, this is my approach to your case, or this is my approach to how I'm going to be supporting you. In the interest of time, I'm going to skip over just some of the benefits and the burdens around remote hearings, all of which I think we were launched into around the time of COVID. And then lastly, just want to tell you a little bit about our newest TA project at the VRLC, which is our LEAP project, Legal Empowerment Advocacy Project. We have a whole safety series of webinars and share and learn calls that we're conducting. They're on safety planning with survivors of stalking, safety planning with survivors of dating violence, safety planning with survivors of non-intimate partner sexual assault, and that's actually just coming up within the week. And then we have a Tips from the Bench series. You'll be hearing from judges in federal court, family court, formerly in criminal cases about their tips for legal advocates on how to effectively advocate in court with survivors. And then we'll be having smaller group conversations, which we call our share and learn calls, population-specific webinars, including we have some I know that are coming up soon with serving both South Asian survivor community and also Asian and Pacific Islander and a legal advocacy guide. So lots of resources. These are the dates of some of the upcoming trainings. You will be getting this PowerPoint, and then also we will be, once we get your email addresses, sending out a resource request form. So, but again, just email us at victimrights.org if you want to know how to get the information for registering for any of these upcoming opportunities. And here's that address. And we are going to take a break, and I'm going to leave it to either OVW or TA to TA to let us know how long that break will be.
Thanks, Jessie. Let's go ahead and reconvene at 4:10. So we'll take a 10-minute break, everyone. All right, everyone, it is 4:10. Welcome back. We're going to be hearing from Jessie again in this final hour today. Just a reminder, we are going to be starting same time, same place tomorrow. If you have any questions between now and then, please feel free to reach out to your program specialist and we will get you some help. And with that, Jessie, go ahead and take it away.
Great, thank you so much. Is this better sound-wise?
Yes, you sound great now.
Wonderful. Well, I wish I could give you all extra OVW funding for having to have lived through that echo for the last hour. So I'm glad we were able to solve it, and thank you all for your understanding. Welcome back. I like opening with this slide, which I will just quickly read to you, because I think it's always so important for us to have our work grounded in what it is that survivors need and what they turn to us for, and the importance of holding our ability to meet those needs. This is from a former VRLC client. We use this with permission. It says, imagine a world in which, in this case, some sexual assault survivors don't feel silenced. Now dream bigger. Imagine a world in which survivors are comforted, believed, supported. Victim Rights Law Center creates that world for so many survivors every day. For me, she wrote, the VRLC has changed, saved, and transformed my life. And this allowed me to imagine and create a world for hundreds of other survivors where they are given the chance to express themselves without judgment and to heal. One of the reasons I want to open with that slide when we're talking about civil legal services for sexual assault survivors is both because of what the capacity that we have to meaningfully support and represent and advocate for survivors of sexual assault, and also in turn to help them reclaim their own lives and go on to do amazing things like this survivor did. So for the next 45 minutes or so, I'm going to be talking with you about LAV, or Legal Assistance to Victims Funded Civil Legal Services for Sexual Assault Survivors. And I thought, since you had to put up with my tech challenges while I'm here in Antarctica, I could at least switch out the photo. So I did that during the break. Instead of seeing me going down the observation tube, which they had drilled into the ice, here you can see two of the Weddell seals that are out right at the very, very beginning of the glacier. So I took that, I think, just a few days ago, and I hope you get some enjoyment from it. And then again, my contact information. I wear several hats at the Victim Rights Law Center. I'm the head of our National Training and Technical Assistance Project, and also I direct the work of the Oregon office, from which we provide free legal services to rape and sexual assault survivors. And then if you need to follow up with us about anything, please do so. It's TA, short for technical assistance, at victimrights.org, victim singular, rights plural. And again, I don't know if there are any of you who are not on the previous 1 hour. I'm assuming that most of you were, and I'm not going to spend much time, but just know that I do not do this work alone. I'm part of an amazing team of lawyers and legal staff who are here to provide the work that all of you do. And I think this is also an opportune moment to mention that in addition to being technical assistance providers, like all of you, we are LAV grantees. So we are funded by the LAV grant program at OVW. And so we're just really intimately familiar with what it means to be a grantee, the ways in which our program managers can support us, what the obligations are, the grant reporting, et cetera. So not only do we have our feet on the ground doing legal services, but in fact are also amongst our LAV funded. Our time together today, my objectives for this presentation is really to talk about, well, who commits sexual assault and who's targeted for sexual assault? What are some of the differences between the legal needs or the remedies that are available to victims of intimate partner violence relative to those that are available to survivors of non-intimate partner sexual assaults? And then hopefully I want to have just a little bit of time at the end, because I know we don't have a lot of time together. It's just beginning to sort of recognize and engage in how your organization can improve access to legal services for survivors of non-intimate partner sexual assault. I know that last time in the earlier presentation, I asked, sort of what your role was. But if you could go ahead, TA to TA, and launch the poll, what kind of organization do you work for? Is it a legal aid program, a domestic violence program, a sexual assault only program? Is it a dual program, going to a domestic violence, sexual assault, and maybe other forms of victimization and interpersonal violence as well? Are you a law school clinic, a state, tribe, or territorial coalition, or other kind of agency? A CAP agency, that's a community, I'm assuming that stands for Community Action Project. Disability rights, immigrant rights, great. And to the person who said, what of you? Yes. Every morning when I leave my office, I make myself pause, or every afternoon, and just out at the oil range and be amazed by where I am. Okay, so I'm seeing that about almost half of you are lawyers or staff with legal aid programs. And then kind of a distribution a lot after that, the next highest is dual, and then domestic violence only. Just a teeny number of only are from sexual assault specific programs only. And then we've got 2 folks who are with Law School Clinic and 3 with Coalition. So thank you. That's just really helpful information to have. For the folks who are with legal aid, know that I and several other of the TA attorneys at the Victim Rights Law Center are former legal aid and legal services lawyers, both LSC and non-LSC funded entities. So we're, again, super familiar with the environment in which you operate. And I spent a number of years at the Oregon Law Center and Legal Aid Services of Oregon and their statewide backup center. So so that we stand with you in that work. And I will also, probably a great time to mention, since I didn't earlier, is that I started out doing this work in the late 1970s as an advocate, first at a domestic violence program, then at a sexual assault program, and worked over the years at each one of those. So very much come from both that advocate-based work, and I also was a trial assistant and alternatives worker in a public defender office. So great to know where all of you are located. I think it's helpful if we're talking about sexual assault specifically in this presentation and webinar today to talk about, well, who is it that commits sexual assault? And I've got this pie chart that comes up, and the categories that you can choose from are current or former intimate partners, acquaintances, relatives, strangers, or victim cannot remember. And again, I'm just going to invite you in the chat box, and let's just say sort of you've got the biggest sector there, which is the blue one. Which of these 5 categories do you think is the blue one, or the largest part of the pie? Which do you think is that green one, which is the next largest part of the pie? So I'm seeing current or former partners. A lot of you are writing that for the blue. Blue, current or former partners. Green is acquaintances. I'm seeing these answers. Current or former for blue. Acquaintances is red. Current is blue. Relatives are green. I love this. Is wonderful. Okay. I'm going to share the next slide with you, which is, this is data, by the way, that comes from the Bureau of Justice Statistics from the Department of Justice. You've got the greatest number here being acquaintance. That is at 39%. Current and former partner is at 33%. We see a lot of variation in the numbers in terms of stranger rape or sexual assault, and this, by the way, includes both rape and sexual assault. It's how their statistics were done. Relative was 6%, and victim cannot remember. And by relative, it's somebody who is not an intimate partner to whom they're related by marriage. And the thing that I always want to emphasize with the current and former intimate partner at 33% is that captures all of the intimate partners. So for example, we've had sexual assault survivors who've contacted us because they're recently sexually assaulted by someone that is their former partner from 5 or 10 or 15 or 20 or more years ago. And that still ends up sort of in this category. I spent some time on this because I think it is really valuable. Just in the previous presentation, I talked about the fact that most sexual assault victims and survivors are assaulted between the ages of 12 and 24, that if we're thinking about providing legal services to survivors, we want to be meeting the need. We cannot be ignoring these other really significant numbers of survivors who are out there in the population. And one of the things that I will freely admit is that particularly in my earlier years at Legal Aid, we would routinely write grants and say that we were going to serve survivors of domestic violence, sexual assault, and stalking. Well, we started off just domestic and sexual violence. Maybe then we added stalking as we learned more about that, or maybe we added in dating violence and or trafficking. But the truth of the matter was that all of our services really were focused on survivors of intimate partner violence. And it was just a colleague who it came from doing actually prosecutions on the rape and sexual assault cases and sex crimes, who really gave me pause and kind of opened up my eyes in a whole new way about all of our invisible clients. And I'll mention that there's just a wonderful law review article out there. It's probably, gosh, 20 plus something years old now, but I think it's unfortunately still very true, by Lois Cantor, who was a longtime clinical law faculty at Northeastern University and also one of the founding board members at the Vrlc. Where she writes about what she called her invisible clients, i.e. the survivors of rape and sexual assault. And here's just another piece of data. Oops, sorry, should be CDC. But according to both the CDC, the Centers for Disease Control, and the U.S. Department of Justice, the majority of rape and sexual assault that's committed against women and girls, and again, it's a binary data collection analysis that they have, is perpetrated by individuals who are not the victim's intimate partner. That is a part of why in this presentation, OVW has asked that we focus on talking about survivors with, who are victimized by, well, first of all, survivors of sexual assault, and in particular with an emphasis in our work on non-intimate partner sexual assault. And I did sort of see in the chat that these statistics might not be true for certain populations. So for example, if we're talking about folks with who are neurodivergent and physical disabilities or intellectual and developmental disabilities, that you may see it from family members or part of the extended community and or caretakers. So within certain populations, this may not be true, but this is sort of overall the data that I'm giving you is from the CDC and from the Bureau of Justice Statistics at the Department of Justice, and that was the BJS data is from 2010 to 2016, and this is just another way of looking at the data. I don't want to spend a ton of time on data, but I think in terms of sort of explaining why it is that we are so feel so urgently about the need to get folks to be expanding their legal services in this arena. So let's turn for a moment to who is targeted for sexual assault and why. We often talk about it as with the acronym VAL, that we know that people who harm and engage in sexual misconduct target victims who are vulnerable, who are accessible, and who are likely to be perceived as lacking in credibility. So I'm going to ask you again, just use the chat. What do you think makes victims vulnerable or accessible to the people who are engaging in sexual harms, or makes these survivors likely to be viewed as lacking in credibility? Go ahead and poverty, yes. No support system, race, individuals with history of substance abuse, great. All of these, absolutely. Homophobia, and I'll add in transphobia. If folks are unhoused, yep. Individuals experiencing mental illness, immigrants, great. Everybody is, when they're minors, they're young, yes. Unemployed, so in other words, often we definitely see a link between the ways in which, the Center for Survivor Agency and Justice talked about this as well, the correlation between victimization and poverty. And I'll add into that also the correlation between poverty and education. One of the things that we know both historically and statistically is that the higher the education, the less likely it is that somebody will either live in or be able to escape from a life of poverty. Non-English speaking, cultural norms related to gender identity, yes, all great comments. And I think you've got probably all of these that I just have here. Individuals with substance use, from misuse and poverty, mental health, individuals with disabilities, individuals with a criminal history are certainly likely to be viewed as not credible. We see that a lot around who is taken seriously with reports to law enforcement. The same also with as a witness in terms of charging decisions. Sexual orientation, gender identity, individuals who are incarcerated or are detained, and also prior victimization. One of the things that we know is individuals who are abused as children are statistically significantly more likely to be raped or sexually assaulted as adults. So I sort of combine both the what makes individuals vulnerable and the what makes them likely to be perceived as lacking in credibility, because we know that those also go hand in hand. One of the questions that we're often asked is, well, why is it that survivors don't report after they have been sexually harmed? What are their experiences after a sexual assault? And then a few years back, somebody on Twitter invited survivors to tweet why they did not report after they had been raped. And I've excerpted just a few of them. I knew I would be blamed or not believed. They say that it can't happen to men. I was too drunk to remember, and certainly we will see the issue of intoxication a lot around credibility in charging decisions. My parents would have killed themselves if they ever found out. This also goes to, I know, social and cultural norms and mores, which one of you had mentioned in the chat. Because he was a police officer. First time I tried telling someone, they asked what I was wearing. It was an orange bikini. I was 12. I wish I could tell you that what survivors are wearing at the time of the assault doesn't matter anymore, but I think all of you would know that that is just not the case. It's no longer true. So these are some reasons why survivors don't report to law enforcement. Let's look at what happens when survivors do report. And these, again, statistics will change over time, but these generally have remained true. For about every 100 rapes that are committed, have about 20% of them that are reported to the police, that are reported to law enforcement. 7 of those will result, so about 50%, these numbers have gone up a little bit, which will result in prosecution. Less than half of those will result in a conviction. And then it's 2.3 that results in incarceration. I'm going to say 2 things about that. And the first is that we know that justice is more than jail for survivors, that survivors will define justice in many, many different ways. Some want that outcome for safety reasons, for psychological, for emotional reasons. Every survivor will define justice system. I certainly am not implying here that the carceral system is the only answer or response to sexual victimization, but it is for some in terms of how survivors define it. And yet we know out of all of the rapes that occur and the sexual assaults that occur, most of them will never end up in the criminal justice system or with this kind of an outcome. And it's why we call our sort of foundational presentation on civil legal remedies for sexual assault survivors, justice is more than jail. Because these are all of the other practice areas where we know, and this is where all of you are engaged in, is that survivors need support around protecting their privacy. Sexual assault survivors tell us, for example, that one of the #1 reasons they do not report to law enforcement is because of privacy. They do not want their family, friends, coworkers, et cetera, finding out. And we know that information is power, and it's part of reclaiming your agency and autonomy after it was taken away from you, is being able to control who knows what about you, when they know about you, how much they know, et cetera. So privacy, safety, which I touched on in the previous presentation, housing, financial, employment, immigration, criminal justice, and I've added in RJ, or restorative justice advocacy. We're certainly seeing increasing interest in that arena, and do know that we have some tips for civil OVW-funded attorneys around restorative justice and working and supporting survivors who may be interested in learning more about that option if it exists in your communities. And of course, family law. Another just quick poll for those of you who know, and you don't know, and I'm not sure is an option in this. How many of you have LAV projects that are focused on, or that are funded primarily for you to be serving survivors of non-intimate partner sexual assault? So the emphasis there is around the non-intimate, because many of you, I'm guessing, will be doing domestic violence and sexual assault, et cetera. There are some of you who are funded just to provide the priority legal services for survivors of non-intimate. That number hovers somewhere between the 15 to 20% range, maybe a little bit higher on the I don't know or I'm not sure. One of the things I can tell you is that for many years, I've been aware, and I know many of you on this phone call will be as well, is that the person who wrote the grant is certainly not the person who is staffing the grant. And for those of you who don't know whether or not the project that you're working under is supposed to be primarily and prioritizing survivors of non-intimate partner sexual assault, I would really urge you to get a copy of the grant if you can, and that's true even if you are a sub-grantee or a contractor. But if you're doing this work, you want to be well informed as to who you are supposed to be serving, who are the priority clients, et cetera. When we do these small group cohorts, which is one of the activities that we offer for LAV grantees of serving sexual assault survivors, just small group cohorts for lawyers who are new to serving sexual assault survivors and or new to lawyering. And then we also will do one for supervisors. But one of the things that we always ask, and I will acknowledge expect, is that they read the grant. And I cannot tell you how many of the lawyers who participate in our cohorts tell us that in preparing for participating in the cohort was the very first time that they ever read the grant that funds them. And so it's just a great place to be able to get that information, and I will urge you to find out. You don't want to be finding it out at the end of your grant when you realize you haven't been funding the folks that you were supposed to be funding, among other things. So I want to turn and just talk a little bit about trauma-informed and survivor-centered legal services for survivors of non-intimate partner sexual assault, particularly because in the last presentation when we had all the microphone challenges, I skipped over a slide that just invited you to talk about what does it really mean to provide these trauma-informed or survivor-centered legal services. We use those phrases a lot, but we don't necessarily offer them some conversation, and so I'm going to ask you to define that. And thank you to the person who mentioned that they were relieved that restorative justice is also being included in this presentation. There's a way that we can support you or your work on that. We would love to do that. There are a number of VRLC attorneys who, with Sujata Balaga, had a chance to go through a 3-day Circle Keeper training, and we have facilitated some share and learn calls and conversations around restorative justice, and that was in part what gave birth to the RJ tip sheet that we created. When you think about survivor-centered or trauma-informed, and I'm guessing that there are a number of you on the call who will would describe your services that way. What does that mean? Think of providing survivor-centered and trauma-informed legal services. In the interest of time, keep us moving and tell you some of the ways in which I've defined it for this presentation. Well, the first is that you understand trauma, that you understand how trauma impacts the actions individuals and survivors may take, how the way in which trauma impacts their ability to process what happened, how it impacts memory, to recall their experience. This is very well established. There are lots of great videos of varying lengths out there. If you want to Google like Dr. James Hopper, who's out of Harvard, or Dr. Rebecca Campbell, Becky Campbell's work on the neurobiology of trauma. She's from Michigan State. Both of them just have some really great, very accessible presentations on YouTube that you can access, understanding the neurobiology of trauma. An intersectional representation, and I'm going to define that in just a moment. Recognizing that there are differences in what the legal needs, what the legal remedies, and also the experiences of survivors of non-intimate partner sexual assault in particular, as they may be distinguished between your clients who are survivors of intimate partner violence. there are lots of intersections and lots of overlapping and similar or identical experiences, but there are also some pretty significant differences, which we'll be talking about. Providing trauma-informed and survivor-centered legal services really also means that you're equipped to identify, to spot, to confront, and whichever way works best for your clients and in the jurisdictions where you practice, the myths and the stereotypes about sexual assault survivors. And to both, but also identify and dismantle the barriers that may exist with respect to access to your own services. And again, one of the questions that I didn't ask here, but I will often ask in a webinar when there's more time, is what percentage of your clients are likely to be minors? And again, because if we're talking about serving sexual assault survivors, and you're talking about meeting their needs and you're not serving minors at all, there's going to be a huge lesion in your ability to serve the survivor community that needs your services. I promised that I would talk a little bit about intersectional lawyering. We describe that at the Victim Rights Law Center as really a legal practice that proactively and holistically and competently integrates some understanding of individuals' various and intersecting identities. It could be with respect to age, whether they're a minor, an older person, their immigration status. And by immigration status, I mean both individuals who are not legally present in the United States, but also those who are. If you're here, let's say on an H-2B visa, which is a work visa, and you are sexually assaulted at work or you're sexually assaulted elsewhere, and it's impacting your work performance such that your employment may be terminated, even though you're legally present in the United States, there will be profound legal implications if you lose your employment status, and that will need to be considered in your legal strategies. It's race, it's gender, and sexual orientation. And we often talk just very generically about LGBTQ community as if it were sort of all one community. So I think it's also important just to underscore that those are very different communities, and individuals may fall in more than one of those categories. You may identify as genderqueer, they may be transgender and lesbian, or transgender and bisexual. So it's very overlapping, but also very distinct communities. And these the experiences of oppression and marginalization, societal and institutional vulnerabilities, all of that needs to inform our legal services in order to provide a trauma-informed, survivor-centered, and survivor-led legal services to the survivors that we're funded to serve and the survivors seeking our assistance. I'm going to pause there and just look at the chat and see whether anybody has any questions or comments. I can see here it's taking the client trauma and experiences in mind and engaging with them, absolutely. Promoting survivor agency. The lawyer is a partner, but not as the authority figure, not the one issuing orders or directives. Listening to and being guided by the survivors there, the experts on their own experience, yes, absolutely. And not only are they the experts on their experience, but they're also the ones who will have to live with the consequences of any decisions that are being made about them, and whether it's made by others or for themselves. And again, that underscores why it's so critical that we be guided by what the survivors know is right for them. It's always important for us as the providers, and also in educating others, which is part of the survivor-led and trauma-informed and intersectional representation, to recognize that we very well may have clients who are engaging in high-risk behaviors and self-harming behaviors. We see that a lot post-sexual assault. Those high-risk activities may be substance use, it may be high-risk sexual activity, it could be cutting, it may be all of the above, but that it is a frequent response for some survivors to the sexual harms and sexual victimization that they've experienced. Also, depression. You know, it's well established that trauma impacts the brain, the chemicals that are released in your body and that your brain releases, and all of that impacts our ability to both, excuse me, to store memories and also to create memories. I remember, in terms of lack of emotion, a case years ago where law enforcement responded, and it was a survivor with disabilities who had been raped, and they had cognitive and developmental disabilities. And one of the things that the police officer wrote in the report was that they didn't find the survivor credible because when law enforcement came, they were laughing and giggling. Well, that was how this particular survivor responded to anxiety-producing events in their life. And so understanding that and being able to communicate that, to advocate with the law enforcement, explain who the survivor is. Hypervigilance is, you know, another very common response. And how does that implicate our legal services? Where we meet with a client, what time of day we meet with a client, the options that we give them in a room in terms of where to sit. I ask permission when I'm meeting with a survivor to close the door. Chances are 99.99% of the time they want the door closed for privacy reasons, but it's this opportunity to give some of the power back to them and also to let them know that they have some choices. And if what they want is to sit, assuming that we can do that in a way that still preserves the confidentiality that they want preserved, it's absolutely an option. Again, I think it's always so valuable to have survivors' voices in the room with us when we're doing this work and having these conversations, and all the more so when we are so far away from each other. And, you know, I can see some of your, a few of the faces on the screen, but for the most part, I'm not even really seeing names, although I do see a few and I recognize those, and that's always very lovely. But this is one survivor who explaining their response. I tried to push it out of my mind, but it was so heavy, I didn't talk. I didn't eat. I didn't sleep. I didn't interact with anyone. After work, I would drive to a secluded place to scream. I became isolated from the ones who I loved most. I showed up an hour late to work every morning and excused myself to cry in the stairwells. Pain became so bad that I had to explain the private details to my boss to let her know why I was leaving. I needed time because continuing day to day was not possible. I used my savings to go as far away as I could possibly be. So if this rape survivor were your client, here's some of the considerations that stand out for you. What areas of law might the survivor need your assistance with? On what topics might you need to be educating a jury or a fact finder or law enforcement or others who are working with this survivor? Take a moment and I invite you to think and reflect on that in the chat. I can offer one that I think will probably stand out for everyone here, which is that they're likely to need legal representation and advocacy around their employment status. For example, if they're talking about showing up for work late every morning, even when they are at work, they're excusing themselves. Come back, because there's a big delay here for how quickly chat are appearing, and I'm seeing it being written, and then I'm not getting it here. Excuse me. Go ahead, and I will come back to it because it will alert me when your chats are up. Oh, here we go. I'm seeing it now. Maybe FMLA, which is Family Medical Leave Act. If the PTSD, post-traumatic stress disorder, is considered a serious medical condition, Possibly unemployment benefits, absolutely. If someone, depending on the jurisdiction, the laws are very different, but in a number of jurisdictions, if a survivor needs to leave their work due to sexual assault or domestic violence or just stalking or other similar victimization, they may be able to be eligible for unemployment remedies. They may be, in the context of work also, you may be thinking about leave. What employment rights do they have? Are they a union and their union contract benefits that have been bargained for? What other paid or unpaid leave options may exist? If they're coming into work late every day, maybe what they need to have is a flexible schedule that will allow them to work later in the come to work later in the day. It's really hard to get up in the morning, get yourself to work on time when you're not sleeping at night. They've mentioned that they use their savings to go as far away as possible. So I would definitely be thinking about crime victim compensation or restitution if there were a criminal case. As LAV funded attorneys, we can't do tort work, but depending upon who was on the other side, I would definitely think about whether it was appropriate to make a referral to a personal injury PI or tort attorney. I can see someone talking about victim compensation, being able to terminate the lease if they're talking about needing to go as far away as possible, so they're probably moving. So just some great suggestions in here. Thank you. Excuse me. When you think about, I love this cartoon, one saying we have nothing in common, and the other person saying, well, I feel the same way. It's sometimes, how I feel when we're talking about domestic violence and sexual assault. There's so many similarities, and there are other ways in which those significances are so different. So I'm just going to invite you, and we'll keep going here, but to identify what are some of the differences that come to mind for you when you think about the differences between serving survivors of intimate partner violence and serving survivors of non-intimate partner sexual assault in particular. We've touched on some of those, throughout this presentation, and even in the conversation that we had earlier before the break around legal advocacy, non-attorney legal advocacy. I'm seeing as a generalization, intimate partner violence survivors are less concentrated in the younger age bracket than our sexual assault survivors. Absolutely. Another one notes we have more information about the abuser, about the batterer when it comes to getting civil protection orders. Great point. Another comment about the age as well. I think these are popping up. It was just earlier, it was taking a while. Go ahead, please feel free to keep writing in there. So I'm going to offer just a few, and some of them you have already identified. Upper right-hand corner, date of birth. Yes, we know most sexual assault survivors are between the ages of 12 and 24. Not that it doesn't happen to individuals who are older and significantly older, or younger and significantly younger. I think at the Victim Rights Law Center, the youngest survivor that we've represented was a 5-year-old, not with our LAV funds, because you can't serve 5-year-olds with LAV money. The oldest was in their early 80s. We talked earlier too about the fact that if you're serving minors and young adults, that where a lot of them are to be found during this daytime is that they're in school. So you need to be thinking about your education practice, about safety planning in the school context, etc. When I first started doing work representing and advocating for survivors, there was not a single state, tribe, or territory that had a civil protection order or restraining order for which a survivor of non-intimate partner sexual assault was eligible. You had to be related by blood or marriage or adoption or otherwise meet qualifying category. And being victimized by a non-intimate partner was not one of those categories. So just around the safety planning, we had huge challenges. Most sexual assaults, in particular on the campus context, are likely to involve alcohol. Alcohol being consumed on the part of the survivor, alcohol being consumed on the part of the person who committed the harms, alcohol being used by the person who engaged in the sexual misconduct to make sure that the survivor was intoxicated. to make it easier to commit to sexual assault. We know that in sexual assault cases, there's instrumental violence. And then last, and by no means least, is this issue of consent, which is that, excuse me, there are only 3 defenses to any sexual assault. It wasn't me, didn't happen, or it was consensual. And the first 2, it wasn't me or it didn't happen, have certainly gotten more difficult to argue with the advent of increasingly sophisticated scientific evidence. Not that it's easy in all sexual assault cases, but it does exist. The majority of sexual assault cases, when we're talking about the criminal justice system, and also I think in a lot, although I don't know the statistics for this, but qualitatively, I would expect that the quote-unquote defense from the respondent or the defendant is going to be that it was consensual. And so being equipped as an attorney representing these survivors, you need to be prepared to respond to the defense of consent. And we do, of course, have more webinars, and we've done some really terrific ones with Equitas, who is one of the other OVW-funded TA providers there on the prosecutor side. But they're really terrific at just about walking through, like, what are some of the ways in which you could generate some compelling evidence, whether it's civil or criminal, around the fact that it was not consensual, but rather it was much more the use of that instrumental violence. I've spoken a fair amount in the last 2 webinars just about ages of who are the victims of rape and sexual assault with respect to minors. But I'm going to kind of focus in on one of these statistics here, which is that more than half of female rape victims were under the age of 18 when they experienced their first attempted or completed rape. I'm hoping by now that you're sort of sensing this theme, which is that if you are not serving these survivors, I think you are really missing an opportunity to meet a very critical and often very urgent need. I do want to just give some tips, and we have a number of webinars and other resources specifically around advocating and representing sexual assault survivors who are minors. But some of the things that you want to be able to think through is what are you going to do when it's the parent who calls you? Because a lot of the time it is, and we have at the Victim Rights Law Center, some pretty firm guidelines around the fact that we want to be in a position to confirm that the survivor is the person who actually wants our services, wants our representation, wants our guidance. It may be an 11-year-old, you may not be having that engagement over the phone, or you may. It's going to depend. There's some pretty sophisticated and 11-year-olds that you'll be talking with on the phone about this, and if not, to do it at your first appointment. Being very clear with a parent or guardian about who the client is, who's directing the representation, as evidenced by the kind of plain language release of information that has some infographics that you saw in the earlier presentation. We really try, in particular with some of our clients, like around youth, for example, and those who are neurodivergent, to use this very straightforward language that's accessible, avoiding legalese with all of our survivor clients. And the attorneys, how we talk about this, even if you have a survivor client who's an attorney, we want to be avoiding sort of just those acronyms and jargon, et cetera. I know that a number of our attorneys at the VRLC who represent minors will be very intentional if they're meeting in person about how they're dressed for that first few appointments, especially, just so that they're not extra and unnecessarily intimidating, but kind of feel accessible. And again, because we're talking about individuals who are in school, for the most part, it's really important to be, hopefully this is probably stating the obvious, but to be available outside of school hours. And to, of course, to offer always appropriate safety planning. I know that in some programs, safety planning will often involve that power and control wheel or the cycle of violence. When we're talking about non-intimate partner sexual assault, please do not assume that it is relevant. Aspects of it may be, but not the way it often is, or to the extent that it is in intimate partner relationships. Again, we did some examples earlier around the VRLC resources. You can see here in the bottom center, Staying Safer on the Streets is that resource that I mentioned we have in English and in Spanish that we also have a guide to that's specific to safety planning with survivors experiencing houselessness in the upper right, where all the drawings are, is if you're doing school related or any other institution or facility where you want to be thinking about how do people enter the building, how do they exit. I remember once in a settlement agreement, one of the terms was that the respondent was only allowed to use a certain doorway and a certain stairwell and was only allowed to park at a different location from where our survivor client parked. And that way our client could know coming into the building, using the stairwell, taking the elevator, that none of those were places where they were going to run into the person who had harmed them. And it allowed both for some additional physical and a lot of just emotional safety. I'm going to quickly read through this and do what will be our last poll, which is again, you have to be ready to educate your fact triers. This is a quote that was taken from the transcript of a civil protection order hearing. The judge said petitioner voluntarily engaged in a drinking contest and had approximately 12 beers between 6 and 10 p.m. Petitioner fell down on her and her hands were bleeding and cut. Her friends, who I find to be very credible witnesses, testified that she was drunk. After those 12 beers between 6 and 10 p.m., petitioner drank 1 to 2 more beers. She testified that there's some periods of time where she does not remember anything. And the judge said to the victim, I've seen the bruises. I know that you did not want this to happen. We're going to do a poll based on these judges' comments. Do you think that the judge granted the victim's request for a sexual assault civil protection order? I really feel so silly, but I just love watching those numbers or percentages of respondents going up. It's just super gratifying. So thank you to everybody who is engaging in that way. Okay, so usually about 2/3 of you said no, 1/3 of you said yes. I'm guessing that at least some of those 2/3 are the fact that I have this in here as a scenario. And as a poll. And here's the judge's response. I think it's more likely than not that you consented. I don't know if you're testifying to things that were told or suggested to you, but for that reason, I am not granting a sexual assault protection order. So she found her credible, having consumed all of this alcohol and nevertheless found that the survivor had consented to the sexual assault. I am pleased to say that they were overturned. The judge was reversed on appeal. This was, again, we're not talking 10, 20, 30, 40 years ago. Unfortunately, we're talking of in 2018, where Judge Marcia Silver, in describing the harms that the 12-year-old victim had experienced, said that they did not suffer any physical or emotional injuries as a result of the rape, other than the ramifications of losing her virginity, which the court does not find to be especially serious harm in this case. By a 6-4 vote, I can tell you that Judge Silva was not sanctioned by her state, although she was not reappointed to the court when her term expired. And last but not least, I just want to wrap up with you thinking about some common barriers in your own organizations to being accessible and providing civil legal services to sexual assault survivors. Oftentimes, folks don't have relationships with the other community partners, whether those are sexual assault nurse examiners, schools, other agencies and organizations who are serving youth. Maybe I know Legal Aid often will do priority setting, and for many years, the program that I was affiliated with didn't have sexual assault as one of the options for priority setting. If all of your partners are domestic violence agencies and you're not partnering with those serving the sexual assault survivor community, your organization doesn't serve minors. You have few partnerships with culturally specific providers. All of these end up being barriers. And I just want to invite you as we close out our time together today to really be thoughtful and thinking about what barriers to accessing survivors services do survivors of non-intimate partner sexual violence experience at your organization? I'm going to close out just with two. This is a organization that was describing that they'll take cases arising out of sexual assault, domestic violence, dating violence, etc. And if you look, everything almost that was listed, or at least the first one, the first four, and then 5 out of the 6, all relate to family law. And similarly, here's another entity that talks about, and this was specific, victims of sexual assault. Are there services? And again, this, what they have listed as relevant are all about domestic violence and how you access forms relative to domestic violence. So we don't have time for you to respond in the chat, but I will both urge, challenge, invite, solicit, and encourage you to engage in that kind of an assessment in your own organizations. And lastly, I just want to remind you that we have many different ways in which we can support your work as TA providers. And thank you finally for all that you do. I want to give a special shout out and thanks to OVW for funding our work as TA providers and inviting us to spend the time with all of you. And also a special thanks to TA for all of their just magical and wonderful and very greatly appreciated support in making this possible. So thank you, everyone. Thank you for those who engaged, who voted, who made comments. I really appreciate the work that you're doing. I'm going to put one last time into the chat that you can reach us at ta@victimrights.org, victim singular, rights plural, one victim, many rights. Thank you, and thank you also for your graciousness with those sound challenges at the beginning. Stay on for just a few more minutes if there's anybody who has any questions.
Thank you, Jessie, and thank you everyone for coming today. We can stay on for a couple minutes, but we'll see everyone tomorrow at 1 p.m. Eastern Time.
Thank you, by the way, for the folks who are thanking me in the chat and for your really just lovely comments. I'm bold and I'm grateful in what you all do. Have a great rest of your day. Take care of yourselves and do good work in the world.
Jessie, I love that I'm still hearing the like seeing all the work you've done for many years and hearing the message again, and I appreciate you.
So, thank you so much. I'm going to stop sharing because partly I just want to encourage all of you to go take care of yourselves. It's been a long day, a lot of sitting and listening, and I appreciate what you do, so take care.